Explore important asset protection strategies for Medicaid planning. These strategies can help preserve your assets for your spouse and heirs while ensuring you remain eligible for Medicaid. Why is asset protection so important? When planning for long-term care, it's crucial to balance protecting your assets with meeting Medicaid eligibility requirements. Preserving your assets ensures your spouse and heirs are not left financially vulnerable. Let's dive into some common asset protection strategies. First, irrevocable trusts. Placing assets into an irrevocable trust means you no longer own them, so they aren't counted towards Medicaid's asset limits. This can be a powerful way to shelter your assets. However, remember that once the assets are in an irrevocable trust, you can't access them or change the trust terms. It's essential to work with an experienced attorney to set up the trust correctly. Second, Medicaid-compliant annuities. These annuities convert a lump sum of money into a stream of income. Medicaid-compliant annuities meet specific requirements to ensure they aren't counted as assets. They must be irrevocable, non-assignable, and pay out within your life expectancy. This strategy can be beneficial, but it's important to understand the terms and potential impact on your income. Third, life estates. Creating a life estate means transferring ownership of your home to someone else while retaining the right to live there for the rest of your life. The value of the home is no longer considered an asset for Medicaid purposes. However, if the home is sold during your lifetime, you may receive a portion of the proceeds, which could affect your Medicaid eligibility. This approach requires careful planning and understanding of your state's rules. Aside from these, there are other legal tools you might consider. Long-term care insurance can help cover the costs of nursing home care, reducing the need to spend down your assets. Family caregiver agreements allow you to compensate family members who provide care, which can also help manage your assets within Medicaid's guidelines. It's crucial to consult with professionals when planning your asset protection strategy. An experienced attorney who has dealt with elder law and Medicaid planning can help tailor these strategies to your specific circumstances. They can provide guidance on the best approach for preserving your assets while ensuring Medicaid eligibility. In summary, protecting your assets is a vital part of Medicaid planning. By using tools like irrevocable trusts, Medicaid-compliant annuities, and life estates, you can preserve your wealth for your loved ones. Consulting with a knowledgeable attorney will ensure your plan complies with Medicaid regulations and meets your personal needs. Thank you for watching. If you have more questions or need personalized advice on asset protection strategies for Medicaid planning, consult with a qualified attorney to explore your options.
In this video, we will explain how a charitable trust works, the benefits it offers, and the steps to establish and manage one. Charitable trusts are legal entities created to manage assets for charitable purposes. The two main types are charitable remainder trusts, or CRDs, and charitable lead trusts, known as CLTs. Each type serves different purposes and offers distinct benefits. A charitable remainder trust allows you to provide income to yourself or other non-charitable beneficiaries for a specified period, after which the remaining assets are transferred to the designated charity. On the other hand, a charitable lead trust provides income to the charity for a specified period. After this period ends, the remaining assets are distributed to your non-charitable beneficiaries, such as family members. Establishing a charitable trust offers numerous benefits. First, the tax benefits are significant. Donors can receive income tax deductions for the value of the assets placed in the trust, reduce estate taxes, and avoid capital gains taxes on appreciated assets. Additionally, charitable trusts support important causes, enabling you to leave a lasting legacy. They also offer financial planning flexibility, providing a steady income stream and professional asset management. Setting up a charitable trust involves several steps. First, define your philanthropic and financial goals and choose the type of trust that best suits your situation. Next, select the charitable beneficiaries and work with an attorney to draft the trust document. Transfer the assets into the trust, appoint a trustee, and obtain a tax identification number for the trust. It's essential to seek professional legal and financial advice throughout this process to ensure compliance and maximize benefits. When establishing a charitable trust, consider the type of assets you will use. Cash and securities are straightforward, but real estate and business interests may require proper valuation and management. Accurate asset valuation is crucial for tax purposes and income distribution. Selecting the right trustee is also vital. The trustee manages the trust's assets, makes income distributions, and ensures compliance with the trust terms. Choose someone experienced and reliable, or consider institutional trustees for professional management. Creating a charitable trust requires ongoing management. Regularly review the trust's performance to ensure it meets its objectives. This includes evaluating investment returns, verifying income distributions, and confirming that charitable beneficiaries use the funds as intended. Adjust the trust terms as needed to reflect changes in your circumstances or goals. Ensure continuous compliance with IRS regulations and legal requirements by consulting with your attorney and tax advisor. Establishing and managing a charitable trust can be complex, but with the right guidance, it can provide significant benefits. By taking the time to understand your objectives and carefully planning the details, you can create a charitable trust that supports the causes you care about while providing financial benefits for you and your heirs.
In our last video, we discussed funeral trusts and spend-down strategies for nursing home care and Medicaid eligibility. Today, we're going to explore an important aspect of Medicaid planning, the look-back period and potential penalties. When you apply for Medicaid, there's a financial review process called the look-back period. This is a span of 5 years during which Medicaid examines your financial transactions to ensure you haven't transferred assets solely to qualify for Medicaid. The purpose is to prevent people from giving away their money or property just to meet Medicaid's asset limits. During this 5-year window, Medicaid looks at any gifts, transfers, or sales of assets you've made. If they find that you've transferred assets for less than fair market value, these transactions may trigger penalties. For example, if you gifted a significant amount of money to a family member within the look-back period, Medicaid may impose a penalty period during which you are ineligible for benefits. Penalties for violating the look-back period rules involve a waiting time before you can receive Medicaid coverage. The length of this period depends on the amount of money or value of assets transferred. Medicaid calculates how long the amount transferred would have paid for your care, and that duration becomes your penalty period. So, how can you avoid these penalties? First, early planning is crucial. Start planning for long-term care and Medicaid well before you need it. This gives you time to arrange your finances in a way that complies with Medicaid rules. Second, be aware of the types of transactions that can trigger penalties. Large gifts, property transfers, and sales for less than market value within the look-back period can all lead to penalties. It's essential to document any transactions and understand their potential implications. Third, consider working with a qualified attorney who has experience in elder law and Medicaid planning. They can help you navigate the complex rules and develop a strategy that minimizes penalties while protecting your assets. Let's look at a couple of real-life examples. Imagine someone who transferred a large sum of money to their children 2 years before applying for Medicaid. This transfer would likely trigger a penalty period, delaying their eligibility for Medicaid benefits. On the other hand, someone who planned ahead and set up an irrevocable funeral trust 5 years in advance would have those funds exempt from the look-back review, avoiding penalties. Even if you haven't planned 5 years in advance, there are still ways to protect some of your funds. Consulting with an experienced attorney can help you explore options like partial asset protection and other strategies tailored to your specific situation. In summary, understanding the Medicaid look-back period and its penalties is vital for effective Medicaid planning. By starting early, avoiding questionable transactions, and seeking professional guidance, you can protect your assets and ensure you're prepared for future long-term care needs. Thank you for watching. If you have more questions or need personalized advice on Medicaid planning and the look-back period, consult with a qualified attorney to explore your options.
Most parents think they're being smart when they add their child's name to their property deed. They believe it's a simple way to avoid probate, save on taxes, or just make things easier when they're gone. But here's the harsh reality that real estate attorneys see every single day. This well-intentioned decision can absolutely destroy your family's financial future. We can tell you that some of the most devastating financial disasters we've witnessed started with parents who thought they were doing the right thing by adding their kids to the deed. These aren't complicated legal loopholes or obscure tax codes we're talking about. These are real families who lost everything because of one simple mistake. Now, before you think this doesn't apply to you because your family gets along perfectly, or because your child would never do anything to hurt you, let me stop you right there. The families I'm about to tell you about thought the exact same thing. They trusted completely. And that trust ended up costing them their homes, their life savings, and in some cases their relationships with their children forever. Today, I'm going to walk you through 5 devastating consequences that happen when you add your child to your deed. And trust me, by the end of this, you'll understand why every estate planning attorney cringes when they hear about parents doing this. We're going to cover real-life examples, the legal nightmares that follow, and most importantly, what you should be doing instead to protect your family's future. But first, let me share something that might shock you. According to recent studies, over 60% of parents have considered adding their children to their property deeds, and nearly 30% have actually done it. That means millions of families across the country are sitting on a financial time bomb, and most of them have no idea. The problem isn't just that this strategy backfires. The problem is that when it goes wrong, it goes catastrophically wrong. We're talking about losing your home while you're still living in it, facing massive tax bills you never saw coming, and watching your children fight in court over property that was supposed to bring your family together. Let me paint you a picture of what this looks like in real life. Picture Sarah, a 72-year-old widow who added her son Michael to her deed 3 years ago. She thought she was being responsible, making sure her house would pass to him without any legal complications. Michael seemed like the perfect choice. He was financially stable, married with 2 kids, and had always been the responsible one in the family. But here's what Sarah didn't anticipate. A few years after she added Michael to the deed, he was named in a lawsuit related to a failed business partnership. Even though the dispute had nothing to do with Sarah or her property, the court issued a judgment against Michael personally. And because his name was on the deed, the judgment creditor placed a lien on the home. Sarah, who had lived in that house for 45 years and raised 3 children there, suddenly found herself unable to refinance, sell, or even borrow against her own home, all because of a legal issue she had nothing to do with. This isn't some rare, once-in-a-lifetime scenario. This is happening to families every single week across the country. And Sarah's situation is actually one of the milder examples we've seen. Some families face even worse consequences that most people never even think about when they're making this decision. The thing that makes this so dangerous is that it feels safe when you're doing it. Your child promises they'll never do anything to hurt you. The paperwork seems straightforward. You might even save a few $1,000s in probate costs. But what you don't realize is that you're trading a small, manageable expense for massive, unpredictable risks that could wipe out everything you've worked for. The first major consequence that catches families completely off guard is what lawyers call joint liability exposure. When you add your child's name to your deed, you're not just giving them ownership rights. You're also making them legally responsible for anything that happens on that property. And more importantly, you're making yourself liable for their financial decisions. Remember Michael from Sarah's story? The moment his name went on that deed, his creditors could legally pursue the house for his business debts. But it gets worse. If your child gets divorced, their spouse can claim a portion of your property in the settlement. If they get sued for any reason, your home becomes an asset that can be seized to satisfy their debts. Image another scenario with Patricia, whose daughter was a doctor. Patricia added her to the deed thinking it would be simple and safe. 2 years later, the daughter was involved in a malpractice lawsuit that went beyond her insurance coverage. The plaintiff's attorneys immediately put a lien on Patricia's house, even though Patricia had nothing to do with the medical incident. Patricia spent 18 months and over $30,000 in legal fees just to protect her own home. Here's what's really terrifying about this scenario. Your child doesn't even have to make bad decisions for this to happen. They could be the most responsible person in the world. But accidents happen, lawsuits occur, and when they do, your property becomes collateral damage. The second consequence is even more insidious because it hits you where you least expect it, your taxes. Most parents think adding their child to the deed will save money on taxes. They couldn't be more wrong. In fact, you're setting your child up for a massive tax bill that could cost them tens of thousands of dollars more than if you had done nothing at all. Here's how this works. When you add your child to your deed, you're essentially giving them a gift of half your property's value. If your house is worth $400,000, you've just made a $200,000 gift. The IRS considers this a taxable event, and if it exceeds the annual gift tax exclusion, you'll need to file gift tax returns and potentially pay gift taxes immediately. But that's just the beginning. The real disaster happens when you pass away. Normally, when a child inherits property, they get what's called a stepped-up basis, which means they inherit it at its current market value for tax purposes. But when they're already on the deed as a co-owner, they lose that benefit for their portion of the property. Let me give you a concrete example. Say you bought your house 30 years ago for $50,000, and it's now worth $500,000. If your child inherits it normally, they can sell it for $500,000 and pay zero capital gains tax because of the stepped-up basis. But if you added them to the deed and they sell after you pass, they'll pay capital gains tax on $225,000 of profit. At current rates, that's over $60,000 in unnecessary taxes. Look, we get it. You want to take care of your family. You want to make things easier for your kids when you're gone. That's exactly what every parent we've worked with wanted to do. But after 15 years of watching families get destroyed by this one simple mistake, I'm telling you there are much better ways to protect your loved ones. The truth is, proper estate planning isn't about taking shortcuts. It's about understanding the risks and making informed decisions that actually protect your family instead of putting them in danger. A well-structured trust, a properly written will, or even just keeping your property in your name until you pass can save your family from financial disaster while still achieving everything you wanted in the first place. Before you make any decisions about your property, talk to a qualified estate planning attorney. Yes, it might cost you a few $100s up front, but that's nothing compared to the hundreds of thousands you could lose by making this mistake. Your family's financial security is worth more than a quick fix that could backfire spectacularly. Don't let good intentions pave the road to financial ruin. Your children will thank you for taking the time to do this right, and you'll sleep better knowing you've actually protected everything you've worked so hard to build. Trust me, the peace of mind is worth every penny.
In this video, we will discuss what a trust is and how it works. A trust is a legal arrangement where one party, known as the grantor, transfers assets to another party, called the trustee. The trustee holds and manages these assets for the benefit of a third party, known as the beneficiary. There are several types of trusts, each serving different purposes. The most common types are revocable trusts and irrevocable trusts. A revocable trust can be altered or revoked by the grantor during their lifetime. This flexibility allows you to make changes as your circumstances or intentions evolve, making it an excellent choice for those who want to retain control over their assets. An irrevocable trust, on the other hand, cannot be easily changed once it is established. This type of trust can provide significant tax advantages and protect assets from creditors, making it ideal for those looking to secure their wealth for future generations. Special purpose trusts are designed for specific goals. Let's look at some common examples. A charitable trust can help you support a cause you care about while potentially offering tax benefits. A special needs trust can provide for a loved one with disabilities without jeopardizing their eligibility for government benefits. A spendthrift trust is useful for protecting a beneficiary who may not be financially responsible. A Medicaid asset protection trust helps individuals qualify for Medicaid while protecting their assets. A testamentary trust is established through a will and goes into effect upon the grantor's death. An asset protection trust is designed to protect your assets from creditors. Creating a trust involves drafting a legal document that outlines the terms of the trust and appointing a trustee. Once established, the grantor transfers assets into the trust, which the trustee then manages according to the trust's terms. The trustee has a fiduciary duty to act in the best interests of the beneficiaries, ensuring the assets are managed and distributed as specified in the trust document. Using a trust offers several benefits. It can help avoid the lengthy and public probate process, ensuring a quicker and more private transfer of assets. Trusts also provide greater control over how and when assets are distributed, which can be particularly useful for beneficiaries who are minors or have specific needs. Additionally, certain types of trusts may offer tax advantages, potentially reducing the overall tax burden on the estate. In summary, trusts are versatile legal tools that can provide significant benefits in estate planning.
You won't believe how many families lose thousands just because of simple estate planning mistakes. Here are the top 5 you need to avoid. Mistake number 1, not having a will at all. Over 60% of adults don't have one. If you die without it, the state decides who gets your stuff, not you. Mistake number 2, forgetting to update beneficiaries. Your ex-spouse could inherit your life insurance just because you forgot to update a name. Seriously, this happens all the time. Mistake number 3, thinking a will avoids probate. It doesn't. A will still goes through court. To avoid that, you need a trust. Mistake number 4, not planning for incapacity. Who handles your finances or makes medical decisions if you're in a coma? If you don't name someone, the court will. And mistake number 5, DIY estate plans. One wrong word or signature could make your whole plan invalid. Saving a few bucks now could cost your family everything later.
A life estate is a form of joint ownership that allows one person to remain in a house until his or her death, then it passes to the other owner. Life estates can be used to avoid probate and to give a house to children without giving up the ability to live in it. They also can play an important role in Medicaid planning. In a life estate, 2 or more people each have an ownership interest in a property, but for different periods of time. The person holding the life estate, the life tenant, possesses the property during his or her life. The other owner, the remainderman, has a current ownership interest but cannot take possession until the death of the life estate holder. Titles and deeds play a pivotal role in legally recognizing and transferring property ownership. Join us as we break it down. What is a title? A title represents legal ownership of a property. It's the evidence that proves you have the right to possess, use, and control a piece of real estate. But what happens when you want to transfer that ownership? The importance of the deed. A deed is the legal document that conveys ownership from one party to another. Think of it as the passport for property, transferring the title and its associated rights. So, how does a typical transfer process look? Time to break it down. Understanding the transfer process. Step 1. Drafting the deed. A deed must include the grantor's and grantee's details, a description of the property, and the type of deed being executed. Step 2. Signature and notarization. The deed is signed by the grantor and often requires notarization for it to be legally valid. Step 3. Recording the deed. The signed deed is filed with the county's Land Records Office, ensuring it's public information and offers protection to the grantee. Deeds aren't all the same. There are different types based on specific situations. Warranty deed. This deed guarantees that the grantor owns the property and has the right to sell it. It provides the most protection for the buyer. Quitclaim deed. Used mainly between family members or in divorces, this deed transfers any ownership interest the grantor might have without any guarantees of that interest's extent. Special warranty deed. The grantor guarantees they haven't encumbered the property during their ownership, but makes no guarantees about previous owners. Navigating the landscape of property titles and deeds can be intricate, but with the right real estate lawyer by your side, the path becomes clearer. For more insights on real estate law, visit our website linked in the description. And remember, for regular legal wisdom, hit subscribe and tap that like button. Have you ever wondered what happens to someone's assets after they pass away? Today, we'll explore the world of probate, breaking it down into steps, as well as looking into the various types that are most appropriate depending on your circumstances. Dealing with assets after a loved one's passing is never easy, but understanding the process can help. Let's break down probate. What is probate? Probate is the formal legal procedure after someone's death, which settles their financial and legal affairs. It is the process that ensures assets are transferred rightly and legally to beneficiaries, and any outstanding debts are settled. But who ensures this process runs smoothly? The crucial role of the executor, that would be the executor, also known as the personal representative. They initiate the probate process, manage assets, settle debts, and ensure the rightful distribution of assets. It's a significant role, oftentimes demanding guidance from experienced probate attorneys. But how do you get started with probate? Let's walk through it step by step. Step 1. Initiating the probate process. Everything begins with appointing a personal representative, either named in the will or chosen by the court. They file a petition for probate, and here, professional legal guidance can be invaluable. Step 2. Inventorying the estate. The representative then takes stock of the deceased's assets, everything from real estate to bank accounts. Step 3. Settling debts and taxes. Before beneficiaries get anything, all debts and taxes must be settled using the estate's assets. Step 4. Distribution. Finally, the remaining assets are distributed according to the will or state laws if there's no will in place. Probate isn't one size fits all. There are different types for varying circumstances. Types of probate. Formal probate. This structured, judge-overseen process is ideal for complex estates or when beneficiaries have disputes. Informal probate. A simpler, quicker process fit for straightforward estates with a valid will and no disputes. Special administration. This method is for when immediate action is required or when full estate administration isn't necessary. Probate may seem complex, but with experienced guidance, you can be sure your estate is managed properly. Be sure to check out additional articles on probate or inquire about a consultation on the Heritage Law Office website in the description below. Also, don't forget to subscribe to the channel for more helpful legal content, and please hit that like button.
Your home is paid off. Your retirement accounts are healthy. You're living the American dream. Then it happens. A stroke. A fall. Alzheimer's creeping in like fog over a harbor. Suddenly, you need round-the-clock care and the bill. Try $120,000 a year, every single year. That's $10,000 a month disappearing from everything you've built. Within 3 years, your life savings are gone. Your spouse is left scrambling, potentially facing poverty after a lifetime of financial responsibility. Your children watch helplessly as their inheritance, meant to secure their own retirements, evaporates into the healthcare system. This isn't a nightmare scenario. This is Tuesday afternoon in America for thousands of families. The truth is, nursing home costs aren't just expensive. They're catastrophic. We're talking about an industry that has turned elder care into a wealth extraction machine. And here's the kicker. Medicare covers almost nothing. Medicaid will help, but only after you've spent down nearly every asset you own. You're essentially required to become impoverished before the safety net kicks in. But what if I told you there are completely legal strategies that savvy families use to protect their assets while still qualifying for benefits? What if there were ways to ensure your spouse doesn't end up destitute, and your children aren't forced to choose between their own financial security and your care? Today, I'm going to walk you through the exact methods that estate planning attorneys use for their own families. The strategies that the wealthy have been quietly employing for decades while middle-class America gets financially decimated by long-term care costs. We'll explore everything from the 5-year look-back period to sophisticated trust structures that can shield millions in assets. This isn't about gaming the system or committing fraud. These are legitimate, court-tested strategies that Congress specifically allows because they recognize that impoverishing families shouldn't be the price of growing old in America. Let's start with the brutal mathematics of nursing home costs, because understanding the scope of this threat is crucial to appreciating why asset protection isn't just smart, it's essential. The average cost of a private room in a nursing home has skyrocketed to over $120,000 annually. In high-cost areas like New York or California, you're looking at $150,000 to $200,000 per year. That's more than most people's entire annual income, and it's due every month regardless of the quality of care. Memory care facilities, which many Alzheimer's patients require, can cost even more. We're talking $180,000 to $250,000 annually for specialized dementia care. And here's what really stings. The average nursing home stay is 2.4 years, but that's just an average. 20% of residents stay 5 years or longer. Some families face a decade or more of these crushing expenses. Do the math. Even at the national average, a 3-year stay costs $360,000. A 5-year stay? $600,000. These numbers aren't theoretical. They're the financial reality facing 1.3 million Americans currently living in nursing homes, with 10,000 baby boomers turning 65 every single day. Medicare, the program most people assume will cover their long-term care, provides virtually no help. It covers skilled nursing care for a maximum of 100 days, and only if you meet to qualify. Where most families make critical mistakes that cost them hundreds of thousands of dollars unnecessarily. Medicaid will cover nursing home costs, but there's a catch. You can only keep $2,000 in countable assets. Your house might be protected while you're alive, but Medicaid has the right to recover costs from your estate after death. Your retirement accounts, your savings, your investments, all of it must be liquidated to pay for care before Medicaid steps in. For married couples, the rules are slightly more generous, but still devastating. The community spouse, the one still living at home, can keep approximately $150,000 in assets and monthly income of around $3,800. Everything above those limits must be spent on the nursing home spouse's care. Imagine working for 40 years, building a $800,000 nest egg, only to watch $650,000 of it disappear into nursing home payments. But here's where it gets interesting. Medicaid has what's called a 5-year look-back period. Any gifts or asset transfers made within 5 years of applying for benefits are scrutinized. Make an improper transfer, and you face a penalty period where you're ineligible for benefits. This is where most families panic and make expensive mistakes. However, and this is crucial, there are numerous exceptions and strategies that allow for proper asset protection even within this look-back period. The key is understanding what Medicaid considers a legitimate transfer versus what triggers penalties. Transfers to certain types of trusts, purchases of exempt assets, and specific gifting strategies can all be done legally and effectively. The wealthy figured this out long ago. They don't lose sleep over nursing home costs because their estate planning attorneys have structured their assets properly. They use irrevocable trusts, strategic gifting programs, and asset repositioning techniques that keep their wealth protected while still qualifying for benefits when needed. The middle class, meanwhile, typically gets advice that sounds something like this. Well, you'll just have to spend down your assets until you qualify for Medicaid. That's not advice. That's surrender. And it's completely unnecessary if you understand the rules and plan accordingly. What we're about to explore are the specific strategies that can protect your assets legally and ethically. From simple techniques that anyone can implement to sophisticated trust structures for larger estates, there are options available at every wealth level. The key is understanding the rules, timing your moves correctly, and avoiding the common pitfalls that trap unprepared families. Because here's the truth they don't want you to know. Asset protection from nursing home costs isn't about being wealthy. It's about being informed. The first and most accessible strategy in your asset protection toolkit is understanding exempt assets. These are resources that Medicaid simply cannot touch, regardless of their value. Your primary residence is an example of an exempt asset, protected in most states. But here's what most people don't realize. You can actually increase this protection by making strategic home improvements or paying down your mortgage with countable assets. Think about it. If you have $100,000 sitting in a savings account, that's a countable asset that must be spent down. But if you use that same money to renovate your kitchen, add a bathroom, or install a new roof, you've just converted countable assets into exempt assets. The value is still there. It's just protected now. This isn't hiding money. This is smart repositioning. Your car is another exempt asset, but only one vehicle per household. Families have legitimately purchased $80,000 luxury vehicles or specially equipped vans and had them considered exempt assets. Again, you're not losing the value. You're converting it into a protected form. However, after you pass away, Medicaid will attempt to recover assets from your estate for any expenses they paid on your behalf. This means they may be able to recover your house or car. To solve this, let's move beyond basic exempt assets and talk about more sophisticated strategies. The irrevocable trust is perhaps the most powerful tool in the asset protection arsenal. When properly structured, these trusts can protect unlimited assets from nursing home costs while still providing some benefits to the person who created them. Here's how it works. You transfer assets into an irrevocable trust, typically naming your children or other beneficiaries as the ultimate recipients. The trust is structured so that you retain certain limited rights, perhaps the right to live in your home if it's transferred to the trust, or the right to receive income from investments held by the trust. The key is that you no longer own these assets outright, so they're not counted for Medicaid purposes. The catch? This strategy requires advanced planning. Remember that 5-year look-back period. Any assets transferred to an irrevocable trust must be done at least 5 years before applying for Medicaid benefits. That's why this isn't a crisis planning technique. It's a long-term strategy that requires foresight and commitment. But what if you're already facing an immediate need for long-term care? What if that 5-year window is closed? Don't despair. There are still powerful strategies available, though they require more sophisticated planning and often professional guidance. The Medicaid-compliant annuity is one such technique. By converting countable assets into an income stream through a specially structured annuity, you can often protect significant wealth while still qualifying for benefits. The annuity must meet specific requirements. It must be immediate, irrevocable, and actuarially sound. But when done correctly, it can preserve hundreds of thousands of dollars. For married couples, the strategies become even more nuanced and powerful. The Community Spouse Resource Allowance allows the at-home spouse to retain approximately $150,000 in assets. But through a technique called spousal refusal, the community spouse can actually refuse to contribute their assets to the nursing home spouse's care. This creates a fascinating dynamic where the nursing home spouse can qualify for Medicaid while the community spouse retains significantly more assets. Asset purchase strategies offer another avenue for protection. Instead of simply spending down assets on nursing home care, families can purchase items that are either exempt or provide ongoing value. Prepaying funeral expenses, buying a more expensive home in a state with higher homestead exemptions, or purchasing certain types of life insurance can all serve as effective spend-down strategies that preserve value for the family. The key to all of these strategies is understanding that Medicaid planning isn't about impoverishment. It's about reorganization. You're not making assets disappear. You're restructuring them in ways that comply with Medicaid rules while still providing maximum benefit to your family. Geographic arbitrage plays a role too. Some states are far more generous in their Medicaid rules than others. The homestead exemption varies dramatically by state. Income and asset limits differ. Even the rules around trust protection vary significantly. Families sometimes relocate strategically to take advantage of more favorable Medicaid rules in their new state of residence. But perhaps the most overlooked strategy is the proper use of caregiver agreements. When adult children provide care for aging parents, this care has real economic value. A properly structured caregiver agreement allows families to compensate adult children for this care, effectively transferring assets while receiving legitimate services in return. The key is documenting the arrangement properly and ensuring the compensation is reasonable for the services provided. Finally, these strategies can often be used together to create a plan that works for your situation. The mistake most families make is waiting until crisis hits before exploring these options. By then, many of the most powerful strategies are no longer available. The 5-year look-back period means that effective asset protection requires the kind of advanced planning that most people resist because it forces them to confront uncomfortable realities about aging and long-term care. While you can still protect a portion of your assets if there was no plan when a crisis hit, planning ahead at least 5 years gives you the biggest opportunity to protect the most amount of assets. This is where the wealthy have always had an advantage. They plan early, they plan comprehensively, and they work with professionals who understand these complex rules. But these strategies aren't reserved for the ultra-rich. Middle-class families can implement many of these same techniques with proper guidance and sufficient lead time. The question isn't whether you'll face long-term care costs. The statistics are clear. Most of us will need some form of extended care before we die. The question is whether you'll face those costs with a plan that protects your family's financial security, or whether you'll join the millions of Americans who watch their life savings disappear into the healthcare system. So there you have it. The roadmap that separates families who preserve their wealth from those who watch it vanish into the nursing home abyss. From exempt asset strategies and irrevocable trusts to caregiver agreements and geographic planning, these aren't just theoretical concepts. They're the actual tools that informed families use to navigate the brutal mathematics of long-term care without sacrificing everything they've built. Remember, this isn't about gaming the system. It's about understanding rules that were specifically designed to prevent the complete impoverishment of American families. The wealthy have been using these strategies for decades, while middle-class America gets steamrolled by costs they never saw coming. The clock is ticking on your planning window. Every day you wait is another day closer to that 5-year look-back period that could lock you out of your best options. Don't be the family that discovers these strategies exist only after it's too late to implement them. Your life savings don't have to become a casualty of growing old in America. With proper planning, the right strategies, and sufficient lead time, you can protect what you've built while still ensuring quality care when you need it. The choice is yours. But the time to make it is now. Thanks for joining me today. If this opened your eyes to possibilities you didn't know existed, share it with someone who needs to hear this message. Because in the end, financial security in retirement isn't about luck. It's about knowledge, and knowledge shared is power multiplied.
A revocable living trust has many benefits over a will, which may make placing your house in a trust a wise decision. For example, to administer a will, it is necessary to initiate a court procedure known as probate. Probate can be a cumbersome and time-consuming process. However, a properly designed revocable living trust has the luxury of being administered in the privacy of your own home or your attorney's office, rather than in the courtroom. This process is private, quicker, and oftentimes significantly less expensive compared to probate. A revocable living trust can avoid the probate process, saving time and money. If you own property in multiple states, such as Minnesota and California, a revocable living trust becomes even more valuable. With a revocable living trust, you will not have to open multiple probates across the different states. Moving your house to a revocable living trust is beneficial in most circumstances. This often raises the question, will a transfer of my home to a trust protect my home from creditors or nursing home expenses? With a revocable living trust, the answer is no. However, another type of trust, an irrevocable trust, may be able to provide you with protection for your home. Moving the house to an irrevocable trust has the result of removing it from your estate. This means it is no longer your asset from a legal standpoint. The house is owned by the irrevocable trust itself, similar to how a corporation can own an asset. Since you no longer own or have control of the asset, the home may be able to be protected from creditors or if you want to apply for Medicaid. Both revocable and irrevocable trusts are important parts of proper estate planning. However, for trusts to function, they must be used and set up properly. Improper use can have a substantial negative effect on your estate. Contact one of our attorneys to make sure your assets are properly protected.
The role of life insurance in succession planning. Welcome back to our series on estate planning for business owners. In our previous videos, we've explored various aspects of business succession planning. Today, we're going to focus on the role of life insurance in succession planning and how it can be a valuable tool in ensuring the smooth transition of your business. Life insurance can play a critical role in business succession planning by providing the necessary funds to address financial needs that arise upon the death of a business owner. Let's look at some specific ways life insurance can be used in your succession plan. First, let's talk about buy-sell agreements. A buy-sell agreement is a legally binding contract that outlines how a partner's share of the business will be handled if they pass away, become disabled, or decide to leave the business. Life insurance can be used to fund these agreements. For example, if you and your business partners each take out a life insurance policy on each other, the proceeds from the policy can be used to buy out the deceased partner's share of the business. This ensures that the business remains in the hands of the surviving owners and provides financial support to the deceased partner's family. Second, life insurance can provide liquidity to pay estate taxes. For many business owners, a significant portion of their wealth is tied up in the business. When they pass away, their heirs may face substantial estate taxes. If there aren't enough liquid assets to cover these taxes, the business might have to be sold or liquidated to pay the tax bill. Life insurance proceeds can provide the necessary funds to pay estate taxes, allowing the business to continue operating without disruption. Third, life insurance can be used to equalize inheritances. If you have multiple heirs, but not all of them are involved in the business, life insurance can help ensure that each heir receives a fair share of your estate. For example, you can leave the business to the heirs who are involved in its operations and use life insurance proceeds to provide an equivalent value to the heirs who are not involved. This can help prevent conflicts and ensure that all your heirs are treated fairly. Another important use of life insurance is in key person insurance. Key person insurance is a policy taken out by a business on the life of an essential employee, such as an owner or top executive. The business is the beneficiary of the policy, and the proceeds can be used to cover the financial loss that occurs when a key person dies. This can include costs related to finding and training a replacement, lost revenue, and reassuring creditors and customers that the business will continue to operate smoothly. When considering life insurance for succession planning, there are several types of policies to choose from. Term life insurance provides coverage for a specific period, making it a cost-effective option for temporary needs. Whole life insurance, on the other hand, provides permanent coverage and builds cash value over time, which can be used for other financial needs. Universal life insurance offers flexibility in premium payments and death benefits, allowing you to adjust the policy as your needs change. It's essential to work with a qualified insurance advisor and estate planning attorney to determine the best type and amount of life insurance for your situation. They can help you understand the options available and ensure that the policies align with your overall succession plan. In summary, Life insurance is a versatile and valuable tool in business succession planning. It can provide the funds needed to buy out a deceased partner's share, pay estate taxes, equalize inheritances, and cover the financial loss of a key person. By incorporating life insurance into your succession plan, you can ensure the continuity and stability of your business for the future. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified estate planning attorney. See you.
Welcome to our comment on estate planning. This presentation aims to provide you with essential knowledge to ensure peace of mind for you and your loved ones. Let's explore the key aspects of estate planning and how it can benefit you. Estate planning involves arranging for the management and disposal of your estate after death or incapacitation. It ensures your wishes are followed and helps minimize taxes, legal fees, and family disputes. Let's delve into why this process is crucial. Estate planning is vital as it protects your loved ones and assets. It helps avoid probate, designates guardians for minor children, and ensures healthcare decisions align with your values. Understanding these benefits is key to effective planning. An estate plan comprises several key components: a will, trusts, power of attorney, healthcare directives, beneficiary designations, and a letter of intent. Each plays a crucial role in ensuring your wishes are respected and executed properly. A will is a legal document specifying asset distribution. It appoints an executor and names guardians for children. However, it must go through probate, which can be time-consuming and costly. Understanding its role is essential in estate planning. Trusts help avoid probate and provide more control over asset distribution. They come in various types, including revocable, irrevocable, special needs, and charitable trusts. Each serves different purposes and offers unique benefits. A power of attorney, POA, appoints someone to handle financial and legal matters if you're incapacitated. A durable POA remains in effect after incapacity, ensuring your affairs are managed according to your wishes. Healthcare directives include a living will, which outlines end-of-life care preferences, and a healthcare proxy, which appoints someone to make medical decisions on your behalf. These documents ensure your healthcare wishes are respected. Beneficiary designations apply to life insurance, retirement accounts, and some bank accounts. They supersede your will, so it's crucial to keep them updated to reflect your current wishes and avoid unintended consequences. Estate taxes can significantly impact your estate's value. The federal estate tax threshold is $13.61 million as of 2025, but this is subject to change. Some states have their own taxes. Using trusts and gifting strategies can reduce tax liability. Avoid common estate planning mistakes: not having a plan, forgetting to update documents, ignoring digital assets, not considering long-term care, and choosing the wrong executor or trustee. Awareness of these pitfalls is crucial. Creating an estate plan involves several steps: taking inventory of assets and debts, identifying goals and priorities, choosing beneficiaries, drafting legal documents, and reviewing regularly. Each step is vital for a comprehensive plan. Update your estate plan during major life events: marriage, divorce, birth or adoption of a child, major asset changes, death of a family member, or changes in tax laws. Regular updates ensure your plan remains relevant and effective. Working with professionals can enhance your estate planning process. Consider consulting an estate planning attorney, financial advisor, tax professional, and trust officer. Their expertise can provide valuable insights and guidance. Final thoughts: estate planning is not just for the wealthy. Start early and review regularly to protect what matters most: your people and your wishes. A well-crafted plan ensures peace of mind for you and your loved ones. We now open the floor for questions. For further assistance, please contact the Heritage Law Office. We're here to help you navigate the complexities of estate planning and ensure your wishes are honored.
Are you confused about estate planning terms? Stay tuned because we're about to simplify them for you. If you find this information helpful, make sure to subscribe to our channel for more tips on estate planning. What is a will? Let's dive right into it. A will is a legal document that outlines how your assets will be distributed after your death. It's a crucial part of estate planning because it ensures that your property is distributed according to your wishes. Additionally, if you have minor children, a will can specify who will take care of them. In summary, a will is essential for outlining how your assets are distributed and who will take care of your minor children. Next up, what is a trust? A trust is a fiduciary arrangement that allows a third party or trustee to hold assets on behalf of a beneficiary or beneficiaries. There are two main types of trusts: revocable and irrevocable. A revocable trust can be altered or terminated by the grantor during their lifetime, while an irrevocable trust generally cannot be changed once it's established. People often set up trusts to avoid probate, reduce estate taxes, and manage their assets during their lifetime and beyond. Power of attorney. Have you ever wondered what a power of attorney is? A power of attorney is a legal document that grants someone else the authority to act on your behalf in financial or legal matters. This person is known as your agent or attorney, in fact. There are different types of powers of attorney, including a durable power of attorney, which remains in effect if you become incapacitated, a springing power of attorney, which comes into effect upon certain circumstances, a financial power of attorney, which specifically covers financial decisions, and a medical power of attorney, which specifically covers medical decisions. Now, let's talk about beneficiary designation. A beneficiary designation is a legal mechanism for naming individuals or entities to receive certain assets upon your death. Common assets that have beneficiary designations include life insurance policies, retirement accounts, and bank accounts. Beneficiary designations are important because they can override your will, so it's crucial to keep them up to date. Healthcare directive. Finally, what is a healthcare directive? A healthcare directive, also known as a living will or advance directive, is a legal document that specifies your wishes regarding medical treatment if you become unable to communicate those decisions yourself. It typically includes instructions on life-sustaining treatments and end-of-life care. Having a healthcare directive ensures that your medical care preferences are known and respected. These are just a few key estate planning terms, but they form the foundation of a comprehensive estate plan. Understanding these terms can help you take control of your future and protect your loved ones. What is a funeral trust fund? A funeral trust fund is a legal agreement that allows you to put aside funds for your funeral and burial expenses. This ensures your final wishes are respected and eases the financial burden on your loved ones. Why is a funeral trust fund necessary? A funeral trust fund is necessary as it offers peace of mind, knowing your loved ones won't have to bear the financial burden of funeral costs. In addition, it provides assurance that your funeral and burial will be conducted according to your preferences. How to set up a funeral trust fund. Setting up a funeral trust fund involves several steps. Determine the amount, consider the type of funeral you want, and the costs associated with it. Include all potential expenses such as the casket, burial plot, and services. Choose a trustee. This could be a family member, friend, or a financial institution. The trustee will be responsible for managing and disbursing the funds after your demise. Create the trust document. This should be done under the guidance of an experienced attorney to ensure the document is legally sound. Fund the trust. You can fund the trust with cash, bonds, life insurance policies, or other assets. It's essential to discuss the most suitable funding option with your attorney. Legal considerations for a funeral trust fund. Funeral trust funds are subject to certain laws and regulations. It's crucial to understand these laws to ensure the trust fund operates as intended. An experienced attorney can guide you through the process, ensuring all legal requirements are met. Advantages of a funeral trust fund. A funeral trust fund offers numerous benefits to the settlor and their loved ones. These include quick accessibility of funds. Unlike other estate assets, funds in a funeral trust are immediately available upon the settlor's death. This eliminates any delay associated with probate and ensures funeral expenses are promptly covered. Flexibility. Funeral trusts can be tailored to meet your specific needs and wishes. You have the freedom to dictate the type of funeral service you want and how the funds should be used. Financial security. A funeral trust fund can alleviate the financial stress on your loved ones after your demise. Knowing that funeral expenses are taken care of can offer them much-needed peace of mind during a challenging time. Disadvantages of a funeral trust fund. While funeral trust funds offer numerous advantages, they also have certain disadvantages. Irrevocability. Some funeral trust funds are irrevocable, meaning once they are established, they cannot be changed or revoked. You should fully understand the terms and conditions of the trust before setting it up. Costs and fees. Creating a funeral trust fund may involve attorney fees and other administrative costs. It's important to consider these expenses when deciding whether a funeral trust fund is the right choice for you. Alternatives to a funeral trust fund. If a funeral trust fund doesn't align with your circumstances, there are alternatives. Life insurance. A life insurance policy can provide funds for funeral and burial expenses. However, these funds may not be immediately accessible upon death, depending on the policy terms. Payable on death account. You could set up a payable on death account at your bank. Upon your demise, the funds in the account are directly transferred to the named beneficiary who can use them to cover funeral expenses. Planning for end-of-life expenses is an act of kindness towards your loved ones. A funeral trust fund can be an effective way to ensure your final wishes are respected and your loved ones are not burdened with unexpected expenses. However, setting up such a trust requires professional legal guidance to navigate complex laws and regulations. At Heritage Law Office, we can help you create a funeral trust fund that aligns with your needs and legal requirements. If you have any questions, please leave a comment and we'll try to answer them. Don't forget to like and subscribe for more helpful content like this. Thank you for watching.
Thinking about how to protect your assets and make life easier for your loved ones? A revocable trust might be the answer. A revocable trust lets you transfer ownership of your assets, like your home and bank accounts, into a trust while keeping full control. You can buy, sell, or move assets in and out of the trust just like always. And since it's revocable, you can change or cancel it anytime you want. One major benefit? Avoiding probate. It's the court process that can be time-consuming and expensive when someone dies with just a will. With a revocable trust, your assets pass directly to your beneficiaries, meaning less hassle and more privacy for your loved ones. Plus, if you become incapacitated, you can name a successor trustee to manage your affairs, avoiding confusion and family conflict.
In this video, we will discuss how to set up a land trust, its benefits, and how it can protect your assets. What is a land trust? A land trust is a legal entity that allows you to manage and control real estate assets while keeping your ownership private. This can be particularly useful for safeguarding your assets from creditors, lawsuits, and other potential risks. With a land trust, you create a private agreement where a trustee holds the title to a property for the benefit of one or more beneficiaries. The main advantage of a land trust is that it allows the beneficiaries to retain control over the property while keeping their identities confidential. Key features of a land trust include privacy, control, and flexibility. The names of the beneficiaries are not disclosed in public records. Beneficiaries maintain control over the property, and they can transfer their interest in the trust without public record changes. What are the benefits of land trusts? People often choose a land trust is the privacy it offers. Since the trustee holds the title, the names of the beneficiaries are not listed in public records, making it difficult for potential litigants to identify the true owners. Additionally, by placing property in a land trust, it becomes more challenging for creditors to seize your assets. Creditors may find it difficult to discover the existence of the trust or determine the property's value, deterring legal actions and settlement negotiations. Land trusts also simplify the process of transferring property ownership. Beneficiaries can transfer their interest in the trust without triggering a public record, useful for estate planning and avoiding probate. How does a land trust work? To establish a land trust, you need to create a trust agreement that outlines the terms and conditions. This document identifies the trustee, beneficiaries, and the powers and responsibilities of each party. An experienced attorney should draft the trust agreement to ensure compliance with state laws. The trustee holds the legal title to the property and manages it according to the trust agreement, while beneficiaries retain control and direct the trustee on property management actions. While land trusts offer numerous benefits, they also have potential drawbacks. They provide limited asset protection compared to other entities like LLCs or irrevocable trusts. Setting up and maintaining a land trust can be complex and may require ongoing legal assistance. Additionally, there may be tax implications, so consulting a tax professional is essential. Integrating land trusts with other strategies. To maximize asset protection, consider integrating land trusts with other legal entities like LLCs, which combine privacy with liability protection. Irrevocable trusts and Medicaid asset protection trusts can also enhance asset protection. Common uses of land trust. Land trusts are popular among real estate investors for anonymous purchases, streamlined transactions, and avoiding due-on-sale clauses. They are also valuable for estate planning, asset management for high-net-worth individuals, and charitable giving. To create a land trust, consult with an experienced attorney, select a reliable trustee, draft the trust agreement, transfer the property title, and maintain the trust. Thank you for watching the video. If you found it helpful, please like and subscribe.
Imagine this. You've spent decades building your dream business, only to have it crumble because of a simple oversight in your estate planning. Sounds dramatic, right? But it happens more often than you think. Picture this. Your family is left fighting over your assets, or worse, your business gets tangled in probate for years. Now, here's the kicker. Many people believe that just having a will is enough. Spoiler alert, it's not. Trust can save your loved ones from a legal nightmare, and they can even protect your business from unexpected taxes. Don't leave your legacy to chance. Plan ahead, avoid the pitfalls, and ensure your hard work doesn't go to waste. Your family and your business will thank you.
Life insurance is a powerful tool in estate planning. Life insurance is a contract between you and an insurance company. In exchange for regular premium payments, the insurance company pays a death benefit to your designated beneficiaries when you pass away. There are several types of life insurance, including term life, whole life, and universal life insurance. Life insurance can be a critical component of your estate plan, offering several key benefits. One of the primary benefits is providing liquidity. When you pass away, your estate may need immediate funds to cover various expenses, such as funeral costs, outstanding debts, and administration fees. Life insurance provides a source of immediate cash, which can help your family cover these expenses without having to sell assets or borrow money. Another significant use of life insurance is paying estate taxes. Depending on the size of your estate and the applicable laws, your estate may be subject to federal and state taxes. These taxes can be substantial and may need to be paid within a relatively short period after your death. Life insurance proceeds can be used to cover these tax liabilities, ensuring that your heirs receive their inheritance without having to liquidate assets to pay the taxes. Let's look at some specific ways life insurance can be used in estate planning. First, funding buy-sell agreements. If you own a business, A buy-sell agreement is a crucial part of your succession plan. This agreement outlines how a partner's share of the business will be handled if they pass away. Life insurance can fund these agreements by providing the necessary cash to buy out the deceased partner's share, ensuring a smooth transition and continuity of the business. Second, equalizing inheritances. If you have multiple heirs and not all of them are involved in the family business or other substantial assets, life insurance can provide a way to equalize inheritances. You can leave the business to the heirs who are involved and use life insurance proceeds to provide an equivalent value to the other heirs, ensuring that everyone is treated fairly. Third, covering final expenses. Life insurance can help cover the costs of your funeral, outstanding debts, and other final expenses. This relieves your family of the financial burden and allows them to focus on grieving and healing. Fourth, providing for minor children. Life insurance can ensure that your young dependents are financially secure. The proceeds can be used to cover their living expenses, education costs, and other needs until they reach adulthood. There are several benefits to using life insurance in estate planning. Life insurance proceeds are generally tax-free for the beneficiaries, providing a tax-efficient way to transfer wealth. Additionally, life insurance offers flexibility and control over the distribution of assets, allowing you to tailor your plan to meet your specific goals. Knowing that your loved ones will be taken care of can provide peace of mind. Setting up life insurance for estate planning involves careful consideration and planning. It's important to work with a qualified estate planning attorney and financial advisor to determine the right type and amount of coverage for your needs. They can help you choose the appropriate policy, designate beneficiaries correctly, and integrate life insurance into your overall estate plan. In summary, life insurance is a versatile and valuable tool in estate planning. It provides liquidity to cover immediate expenses, helps pay estate taxes, funds buy-sell agreements, equalizes inheritances, covers final expenses, and provides for minor children. By incorporating life insurance into your estate plan, you can ensure the financial security of your loved ones and the smooth transition of your assets. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified estate planning attorney or financial advisor. See you in the next video.
Some people believe that wills are only necessary for the very wealthy or those with complicated assets. However, there are many good reasons to have a will. You can be clear about who gets your assets. You have more control and can decide who gets what and how much. Your heirs will be able to access your assets more quickly and easily. Additionally, with proper planning, you can plan to save your estate money on taxes. You can also give gifts and charitable donations, which can give tax benefits. However, even if you have a will, upon your passing, your assets will be routed through the probate process. Probate is the legal process that occurs to your estate after you pass away. This is a court-monitored process where the debts of the estate are paid and distribution is made to the heirs. The probate process will flow smoother with a will. Probate costs money and can take significant time. With proper estate planning, probate may be able to be avoided. Trusts can accomplish the same goals as a will, but oftentimes in much better fashion. When a trust is properly set up, it can avoid probate entirely. Any assets that belong to the trust will not be routed through probate. Often, a type of will, a pour-over will, is used in conjunction with creating a trust to ensure all assets are covered, even if they are not properly moved to a trust. To ensure your will or trust is done properly, contact Heritage Law Office today.
Here's a number that surprises most people. Roughly 2 out of 3 Americans die without a will. They don't intend to, they just never get around to it, and then it's too late. And when that happens, the state steps in and decides who gets everything you built. Not you, not your family, the state. What I'm about to walk you through is what actually happens to your home, your savings, and your kids if you die without a will. It's not what most people expect. And once you hear it, you'll understand why this is the most important paperwork you'll ever sign. So let's start with the basic question. If you die without a will, what happens to your stuff? Here's the honest answer. Your stuff doesn't just disappear, it goes to court. A process called probate. The state appoints someone to take an inventory of everything you own, pay your debts and taxes, and then distribute what's left. But here's the catch. The state isn't distributing your assets according to what you would have wanted. It's distributing them according to a rigid, one-size-fits-all formula called the laws of intestacy, which literally means dying without a will. And that formula often does not match what a real family would choose. Your stepchildren, your close friends, the charities you cared about, your long-term partner if you never married, under this formula, they may get nothing at all. Let's make this concrete, because this is where it gets personal. Say you own a home and have a life insurance payout sitting in savings, and you pass without a will. If you're married, your spouse doesn't automatically get everything. In many states, they get a share, and the rest is carved up among your children. If you have kids from a previous marriage, the state may divide your home between your new spouse and those children, creating a situation where your spouse must either buy out your kids, sell the family home, or share it with people they may not get along with. If you're unmarried but living with a partner, a very common situation, your partner inherits nothing unless the property is titled in both names. The entire estate may go to blood relatives you haven't spoken to in years. And if you have no relatives at all, the state can claim your entire estate. Everything you worked for goes to the government. Here's the part that keeps estate attorneys up at night, and it's the reason this video exists. If you die without a will and you have minor children, you have not named a guardian. That decision, who raises your kids if you're gone, does not get made by you. It gets made by a judge. The judge will consider family members, and sometimes the state will place your children with someone you would never have chosen. Your child's future is decided by a stranger in a courtroom, based on a formula, not on your wishes. You named a guardian in your mind 1,000 times, maybe your sister, maybe your best friend, but in your mind is not a legal document. If it's not written down, it doesn't exist. This is the single most important reason to have a will, not for your money, for your children. A will is the only document that lets you choose who raises them. So by now you might be thinking, fine, I'll get a will. And you should. But here's the honest truth. A will is the foundation, not the whole house. A will does 3 essential things. It names your executor, it names a guardian for your kids, and it says who gets your assets. It's one of the most important documents you'll ever sign. But it does not automatically protect your home from nursing home costs. It does not automatically avoid probate, and it does not handle the 3 biggest threats to everything you've built. That's what this series is about. Over the next few videos, I'm going to show you the specific legal tools that protect your home and savings from the 3 things that drain family estates: nursing home costs, probate fees, and family conflict. You're watching video 1, the foundation. Get the will right, and the rest of the structure has somewhere to stand. Here's the thing I need you to hear, and I'll say it plainly. The best time to do this was years ago. The second best time is this week. I know it feels like a task for someday, but I've seen too many families learn the hard way that someday doesn't wait. The health crisis that lands you in a nursing home doesn't check your to-do list first. It doesn't wait until you've drafted your documents. It arrives on its own schedule, and if your plan isn't in place, it's too late for the tools that require planning in advance. That's the uncomfortable truth about estate planning. The most powerful protections, the ones that shield your home from the nursing home, the ones that keep your savings out of probate, have to be set up while you're healthy. Not in the middle of a crisis, before. So here's what I want you to take away. Without a will, the state decides who gets your home, your savings, and your kids. 2 out of 3 Americans never write one, and their families pay the price in court fees, conflict, and lost control. But a will is just the foundation. The real protection for your home and your life savings comes from the tools I'm going to show you next. If you want to make sure your family is protected, the first step is a conversation. Reach out to an attorney. Subscribe and turn on notifications so you don't miss the next video.
Today, we're diving into a critical issue that affects many homeowners: HOA overreach. Homeowners associations are designed to enhance and maintain the quality of our communities. However, when an HOA oversteps its bounds or fails to meet its obligations, it can create serious problems for homeowners. In this video, we'll guide you on recognizing and effectively combating HOA overreach. Recognizing HOA overreach can manifest in various ways, including: Number 1. Excessive fees. This includes unjustified increases in costs or unexpected assessments. Number 2, unfair rule enforcement. This means selective or inconsistent application of rules. Number 3, poor financial management. This refers to mismanagement or lack of transparency in handling community funds. Identifying these issues early is crucial to protecting your rights as a homeowner. To build a strong case, meticulous documentation is key. Keep communication logs, record all emails, letters, and phone calls with HOO representatives. Keep meeting minutes. Keep copies of official meeting notes and any personal notes taken during meetings. Document incidents. Record specific incidents of overreach, including dates, times, and descriptions. This documentation will be invaluable if you need to escalate your complaint. Start by addressing the issue within the HOA. Attend meetings. Be an active participant in HOA meetings. This is your platform to voice concerns and suggest changes. Communicate clearly. Present your case calmly and factually to the board. Sometimes, open dialogue can lead to resolution without further conflict. If internal efforts fail, it might be time to seek external help. Mediation. A neutral mediator can help facilitate a fair resolution without going to court. Legal counsel. If mediation doesn't work, consulting a lawyer who's experienced in HOA disputes may be necessary. Legal action should be a last resort, but can be effective if your rights are being violated. Consider the story of Sarah, a homeowner who faced unreasonable fines and mismanagement of community funds by her HOA. By diligently documenting the issues and seeking legal counsel, her persistence led to a fair resolution, improved community governance, and protection of her rights. Don't let an overreaching HOA disrupt your peace of mind. Feel free to take action if you're facing issues with your HOA. Protect your rights and ensure your community is managed fairly. For more information or assistance, contact us today. Remember to like, share, and subscribe for more valuable insights on protecting your rights as a homeowner. See you in the next video.
In this video, we will explore the benefits and process of buying property through a trust. A trust is a legal arrangement where one party, known as the trustee, holds property for the benefit of another party, known as the beneficiary. Trusts can be used for various purposes, including estate planning, asset protection, and privacy. One of the main benefits of buying property through a trust is asset protection. Properties held in a trust can be shielded from creditors' claims and lawsuits. Additionally, trusts offer privacy by keeping ownership details out of public records. When it comes to estate planning, trusts allow for the efficient transfer of assets upon the owner's death, avoiding the lengthy and costly probate process. Trusts also provide control over how and when assets are distributed to beneficiaries. Properly structured trusts can offer significant tax benefits, reducing estate taxes and providing other tax advantages. Several types of trusts can be used for buying property. A revocable trust allows the grantor to retain control and make changes to the trust. This type of trust is ideal for estate planning and can simplify the transfer of property after death. A irrevocable trust, once established, cannot be altered or revoked. This type of trust provides stronger asset protection and potential tax benefits. Charitable trusts allow property owners to support charitable causes while receiving tax benefits. Special needs trusts are designed to provide for beneficiaries with special needs without affecting their eligibility for government benefits. Now, let's go through the steps to buy property through a trust. First, establish the trust with the help of an experienced attorney. This involves drafting the trust document and naming the trustee and beneficiaries. Next, find a suitable property that aligns with your investment goals and the terms of the trust. If financing is needed, work with lenders who are familiar with lending to trusts. Ensure the property is titled in the name of the trust, not the individual, to maintain the legal protections and benefits of the trust structure. Once the property is purchased, the trustee will manage it according to the trust terms, ensuring that all obligations, such as taxes and maintenance, are met. Trustee duties include managing trust assets, maintaining the property, keeping up with property taxes and insurance, and acting in the best interests of the beneficiaries. Trustees must also keep detailed records and provide regular reports to the beneficiaries. Beneficiaries have the right to access trust documents, receive regular updates, and receive distributions as specified in the trust document. They must comply with the terms and conditions outlined in the trust and stay informed about the trust's activities. Key considerations for buying property through a trust include understanding the legal and tax implications. Trust laws can vary by state, so it's important to ensure compliance with local regulations. Engage an experienced attorney to navigate the complexities of setting up and managing a trust. Practical steps for trust management include regular property inspections, creating a budget for property expenses, and developing a prudent investment strategy for any income generated by the property. In summary, buying property through a trust offers significant benefits, including asset protection, privacy, estate planning advantages, and tax benefits. However, it requires careful planning and management. Consider seeking professional advice to ensure your real estate investments are secure, efficiently managed, and aligned with your long-term goals.
When someone close to you passes away, dealing with their estate through probate can feel like navigating a maze while you're still grieving. But here's the thing most people don't realize. Probate doesn't have to be the nightmare everyone makes it out to be. I've been helping families through this process for a while, and I can tell you that with the right approach, you can turn what feels like an impossible mountain into manageable steps. Today, I'm going to walk you through the 5 essential keys that will make your probate experience as smooth as possible. These aren't just theoretical concepts either. I'm talking about real strategies that have saved my clients thousands of dollars and months of frustration. By the end of this video, you'll know exactly what to expect and how to avoid the most common pitfalls that trip up 90% of families going through probate. Key number 1 is understanding the timeline and staying ahead of deadlines. Most people think probate just happens automatically, but the reality is far different. There are specific deadlines you must meet, and missing even one can cost you dearly. The court doesn't care if you are grieving or overwhelmed. They expect notices to creditors within a certain time frame, inventories to be filed on schedule, and final distributions to happen according to their calendar, not yours. I always tell my clients to think of probate like a chess game where every move has consequences, and timing is everything. Key number 2 revolves around proper documentation and organization. Here's where most families stumble badly. They'll spend weeks searching for a single document that should have been organized from day one. Create a master file system immediately. Bank statements, insurance policies, property deeds, tax returns from the past 3 years, and any business documents need to be categorized and accessible. I've seen probate cases drag on for years, simply because someone couldn't locate a critical piece of paperwork when the court demanded it. Key number 3 is managing family dynamics and communication. This one might surprise you, but family conflict is the number 1 reason probate cases turn ugly and expensive. Even the most loving families can fall apart when money and property are involved. Set up regular family meetings, keep everyone informed about the process, and establish clear boundaries about decision-making authority. Remember, the executor has legal responsibilities that sometimes require making unpopular decisions, and that's okay. Key number 4 focuses on working with the right professionals. Trying to handle probate alone is like performing surgery on yourself. You might save money up front, but the mistakes will cost you far more in the long run. A qualified probate attorney isn't an expense. They're an investment in getting things done correctly the first time. Look for someone who has experience in probate, not just general practice law. Ask about their typical timeline for cases like yours, and make sure they explain everything in terms you can understand. Key number 5 is protecting estate assets throughout the process. This means securing property, maintaining insurance coverage, and making smart decisions about when to sell assets versus when to hold on to them. Market timing can make a significant difference in the final value of an estate, and understanding tax implications before you act can save thousands. The probate process doesn't have to define this chapter of your family's story. With proper preparation, clear communication, and the right professional guidance, you can honor your loved one's memory while protecting what they worked so hard to build. These 5 keys have helped hundreds of families navigate probate successfully, and they'll work for you too.
To date, we're going to talk about a topic that many might overlook: funeral trusts. A funeral trust is a legal arrangement you set up in advance to cover your funeral expenses. It ensures that the money you set aside will be used specifically for your funeral costs, alleviating financial and emotional stress for your family during a difficult time. A funeral trust is a financial arrangement in which funds are set aside to pay for your future funeral and burial expenses. This trust can be revocable, meaning you can change or cancel it, or irrevocable, meaning once it's set up, it can't be altered or revoked. So why consider a funeral trust? Here are a few key benefits. Number 1, financial protection. Funeral trusts can help protect your assets from being used for other purposes. This is especially important for individuals seeking to qualify for Medicaid, as funds in an irrevocable funeral trust are typically exempt from asset limits. Number 2, peace of mind. Knowing that your funeral expenses are covered provides peace of mind for both you and your loved ones. It's one less thing for your family to worry about during a time of grief. Number 3, cost control. By setting up a funeral trust, you can lock in current prices for funeral services, protecting you from inflation and rising costs over time. Now, let's talk about how to set up a funeral trust. There are a few key steps to follow. First, consult with a professional. Work with a qualified attorney or financial advisor to understand your options and ensure the trust is set up correctly. Next, choose a funeral provider. Select a funeral home or provider and decide on the services you want. This could include everything from burial or cremation to specific types of services and merchandise. Then, fund the trust. Transfer the funds into the trust. The amount you deposit will depend on the estimated cost of your chosen funeral services. Before setting up a funeral trust, here are a few important considerations. Firstly, decide whether a revocable or irrevocable trust is best for your situation. Each has its advantages and limitations. Secondly, understand that funeral trust laws vary by state, so it's crucial to be aware of the regulations in your area. Finally, choose a reliable trustee who will manage the funds and ensure they are used appropriately when the time comes. While it's a difficult topic to think about, setting up a funeral trust is a thoughtful and practical step that can provide significant benefits. It's about planning ahead and making sure your final wishes are honored without placing a financial burden on your loved ones. Thank you for watching. If you have more questions or need guidance on setting up a funeral trust, consult with a qualified attorney to explore your options.
Gift tax? Most people get this completely wrong. Let me break it down with 2025 rules. The IRS lets you give someone up to $19,000 in 2025 without triggering gift tax. Sounds like a lot? You can do that for each person you gift. And if you're married and use gift splitting, you and your spouse can each give $19,000. That's $38,000 per recipient, no tax. What about bigger gifts? Here comes the lifetime exemption. In 2025, it's $13.99 million per person. That covers gifts plus your estate. That means if you exceed the annual $19,000, you probably still won't owe tax. You'll just use up part of your lifetime exemption. But you may need to file IRS Form 709 to report it. Smart strategies people use. Spread out gifts over years so you stay under the annual limit per person. Pay tuition or medical costs directly to the institution. Those are still fully exempt. Gift appreciating assets early, like stocks or real estate. So future growth happens outside your taxable estate. Heads up, starting January 1st, 2026, the One Big Beautiful Bill. Act permanently raises the lifetime exemption to $15 million per person and $30 million for married couples, indexed for inflation. So here's the punch. With smart planning, you can give generously, without gift tax drama.
In this video, we will discuss how to manage inherited property during probate, covering essential steps and common challenges you may face. Welcome to our channel. If you're dealing with the complexities of probate and inherited property, this video is for you. Let's dive into the key aspects of managing inherited property during probate. First, let's understand the probate process. Probate is the legal procedure of administering a deceased person's estate, ensuring debts are paid, and distributing the remaining assets to the rightful heirs. When handling inherited property, you'll need to locate and review the will, inventory the estate, notify creditors, settle debts, maintain the property, and decide on its future. One of the common challenges in handling inherited property is emotional attachment. Family disagreements can arise when heirs have differing opinions on what to do with the property. Sentimental value can also complicate decisions about selling or renting the property. Additionally, financial considerations like the costs of maintaining the property and potential tax implications need to be addressed. Legal complications, such as dealing with multiple heirs or unresolved debts, can also present challenges. If you decide to sell the inherited property, there are several steps to follow. First, prepare the property for sale by making necessary repairs and upgrades, and ensure it is clean and staged. Hiring a real estate agent experienced in estate sales is crucial. They can help you list the property, conduct a market analysis, and market it effectively to attract buyers. Finally, navigate the sale process by evaluating offers, negotiating terms, and finalizing the sale with the help of your agent and attorney. Here are some practical tips for handling inherited property efficiently. Stay organized by keeping meticulous records of all transactions and communications. Use digital tools and software to track important documents and deadlines. Seek professional advice from estate attorneys and financial advisors to navigate legal complexities and plan for tax implications. Communicate effectively with family members through regular meetings and open discussions. Lastly, be patient and compassionate, recognizing the emotional impact of losing a loved one and providing support to each other. In summary, managing inherited property during probate involves understanding the probate process, addressing common challenges, and following practical tips to navigate the complexities. If you need assistance, our knowledgeable attorneys are here to support you every step of the way. Contact us to ensure the probate process is as smooth as possible. Thank you for watching. If you found this video helpful, please like, share, and subscribe to our channel for more informative content.
Welcome to our series on franchise law. Today, we're discussing the legal aspects of buying or starting a franchise. Understanding these aspects is crucial for making informed decisions and ensuring your business venture is successful. First, what is a franchise? A franchise is a business model where a franchisor grants a franchisee the right to operate a business using the franchisor's brand, products, and systems. The franchisee pays fees and agrees to operate the business according to the franchisor's guidelines. When considering a franchise, there are two primary legal documents you need to be familiar with: the Franchise Disclosure Document, or FDD, and the Franchise Agreement. The Franchise Disclosure Document, or FDD, provides detailed information about the franchisor and the franchise system. It includes the franchisor's history, litigation history, financial statements, initial and ongoing fees, and obligations of both parties. Reviewing the FDD thoroughly is essential. The Franchise Agreement is the binding contract between the franchisor and franchisee. It outlines the terms and conditions of the franchise relationship, including the rights and responsibilities of each party. Key terms to understand include the duration of the franchise, renewal terms, territorial rights, and conditions for termination. Conducting thorough due diligence is critical before buying a franchise. This involves reviewing the FDD, researching the franchisor's history and reputation, and understanding the financial commitments and projections. When buying a franchise, there are several legal considerations to keep in mind. Initial franchise fees and ongoing royalties. Understand the total cost involved. Territorial rights and restrictions. Know your exclusive territory and any restrictions. Intellectual property rights. Understand your rights to use the franchisor's trademarks and proprietary systems. Obligations of the franchisor and franchisee. Clarify the support and training provided and expected. Renewal and termination clauses. Pay attention to the terms for renewing or terminating the agreement. Starting a franchise involves several key steps. Ensure legal compliance by registering your franchise and adhering to state-specific regulations. Develop an operations manual outlining how the franchise should be run. Protect your intellectual property by securing trademarks and trade secrets. Financial aspects are important. Explore financing options for buying or starting a franchise and understand the initial investment required, as well as ongoing expenses and royalties. Franchisee support and training are vital for success. Most franchisors provide initial training and ongoing support to help franchisees run their businesses effectively. Take full advantage of these resources. Disputes can arise in any business relationship. Common disputes in franchising include disagreements over territory, fees, and performance standards. Methods for resolving disputes include mediation, arbitration, and litigation. Address disputes promptly and seek legal advice if necessary. In conclusion, buying or starting a franchise involves navigating several legal aspects, from understanding the FDD and franchise agreement to conducting due diligence and ensuring legal compliance. Consulting with a qualified franchise attorney is essential to protect your interests and make informed decisions. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified franchise attorney. See you in the next video.
Do you actually need a power of attorney? Or is it just something lawyers try to sell you? Here's the truth. If you become incapacitated tomorrow, who pays your bills? Who makes your medical decisions? Without a power of attorney, your family has to go to court. That process can take months and cost thousands. A power of attorney lets someone you trust step in immediately. No court, no delays. So ask yourself, do you have assets, a family, a business? Are you over 18 years old? Then yeah, you probably need one. Drop a comment if you've set yours up or tell me what's holding you back.
Welcome back to our series on estate planning. Today, we're going to discuss funeral trusts and Medicaid and how they can be used for effective asset management. First, let's define what funeral trusts are. A funeral trust is a legal arrangement where you set aside funds specifically to cover your funeral and burial expenses. These trusts can be either revocable or irrevocable. Revocable trusts can be altered or canceled by the grantor at any time, while irrevocable trusts cannot be changed once they are established. So, how do funeral trusts work? When you set up a funeral trust, you deposit money into the trust, which is then used to pay for your funeral expenses when the time comes. Typical costs covered by funeral trusts include burial plots, caskets, funeral services, and other related expenses. Understanding Medicaid eligibility is essential for proper asset management. Medicaid has strict asset limits that you must meet to qualify for benefits. This means you may need to spend down your assets to become eligible. Properly managing your assets can help you qualify for Medicaid without depleting all your resources. This is where funeral trusts come into play. Funeral trusts can help protect your assets and ensure you qualify for Medicaid. When you set up an irrevocable funeral trust, the funds placed in the trust are not counted as assets when determining Medicaid eligibility. This means you can set aside money for your funeral expenses without affecting your eligibility for Medicaid. There are several benefits to using funeral trusts for asset management. First, they ensure that funds are available to cover your funeral expenses, relieving your family of the financial burden. Second, by setting up a funeral trust, you can reduce the amount of countable assets, helping you qualify for Medicaid. This allows you to protect your savings and still receive the care you need. Setting up a funeral trust involves a few key steps. First, you'll need to consult with a qualified attorney or financial advisor who specializes in estate planning and Medicaid. They can help you determine whether a revocable or irrevocable trust is best for your situation. Once you've decided on the type of trust, you'll need to complete the necessary paperwork and fund the trust with the appropriate amount of money. Common questions and concerns about funeral trusts often involve the differences between revocable and irrevocable trusts, the amount of money that can be placed in the trust, and how the funds will be used. It's important to work with a professional to address these questions and ensure your trust is set up correctly. Let's look at a real-life example. Imagine someone who has significant savings and is concerned about qualifying for Medicaid. By setting up an irrevocable funeral trust, they can set aside a portion of their savings for funeral expenses, reducing their countable assets and helping them qualify for Medicaid. This not only ensures their funeral expenses are covered, but also allows them to receive the care they need without depleting all their resources. In summary, funeral trusts are a valuable tool for asset management and Medicaid planning. They provide a way to set aside funds for funeral expenses, protect assets, and help you qualify for Medicaid. By incorporating funeral trusts into your estate plan, you can ensure your financial future is secure and your loved ones are taken care of. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified estate planning attorney or financial advisor. See you in the next video.
Most families think they've got their estate planning sorted out when they write a will. But here's the harsh reality. They're setting their loved ones up for months of legal headaches, thousands in unnecessary fees, and family drama that could tear relationships apart forever. I've seen it happen countless times, and today I'm going to show you exactly why the choice between a will and a trust could be the difference between leaving your family a gift or leaving them a nightmare. Look, I get it. When most people think about estate planning, they immediately jump to wills because that's what everyone talks about. Your parents probably had a will, your grandparents had a will, and every movie you've ever watched shows some dramatic will reading scene. But here's what nobody tells you. Wills are actually one of the worst ways to transfer wealth to your family. Now, before you think I'm completely crazy, let me explain exactly what I mean. I'm going to break down the real differences between wills and trusts in a way that actually makes sense, without all the legal jargon that usually makes your eyes glaze over. By the end of this video, you'll understand why most wealthy families use trusts, and more importantly, how you can protect your family the same way. But first, let me share a story that perfectly illustrates why this matters so much. Meet a woman named Sarah. Her dad had passed away suddenly, leaving behind a house, some investments, and what everyone thought was a simple will. Sarah assumed everything would be straightforward. After all, her father had been organized, he'd written everything down clearly, and the will seemed to cover all the basics. But what happened next was a complete disaster. The will had to go through probate court, which meant every single asset became public record. Suddenly, distant relatives she hadn't spoken to in years started coming out of the woodwork, claiming they deserved a piece of the inheritance. The legal fees started piling up. First, it was a few $100s here and there. Then it became thousands. The house couldn't be sold because it was tied up in probate. The investment accounts were frozen. And Sarah found herself spending every weekend dealing with lawyers, court filings, and family members who were suddenly very interested in her father's money. 18 months and $23,000 in legal fees later, Sarah finally received what should have been hers from the beginning. But by then, the stress had taken its toll. Her relationship with her brother had completely fallen apart over disagreements about the estate. Her mother was devastated by all the family conflict. Sarah wouldn't wish that experience on her worst enemy. The crazy part, your will becomes a public document that gets filed with the court. Every asset you own, every debt you owe, and every person who benefits from your estate becomes public information that probate fees typically run between 3 and 7% of your total estate value. So, if you're leaving behind a $400,000 house and some investments, your family could be looking at $20,000 or more in fees before they see a single penny. That's money that should be going to your kids or grandkids, but instead it's padding some lawyer's bank account. Now, here's where trusts completely change the game. Think of a trust as a special container that holds your assets while you're alive and then seamlessly transfers them to your beneficiaries when you're gone. No court involvement, no public records, no waiting periods, and dramatically lower costs. When you create a trust, you're essentially creating a separate legal entity that owns your assets. You remain in complete control as the trustee while you're alive, so nothing changes in your day-to-day life. You can still buy, sell, and manage everything exactly like you always have. But when you pass away, a successor trustee you've chosen steps in and distributes everything according to your wishes, usually within a matter of weeks. Think about it this way. You wouldn't leave your family a gift wrapped in barbed wire, so why leave them an inheritance wrapped in legal red tape? The choice between a will and a trust isn't just about paperwork. It's about whether you want to leave your loved ones a blessing or a burden. Don't make the same mistake Sarah's father made. Your family deserves better than months of court battles and thousands in unnecessary fees when you could give them the gift of a smooth, private transfer that protects their relationships and their inheritance.
If something happened tomorrow, would your family know what to do? In this video, I'll guide you through a simple estate planning roadmap. Let's take a look at the phases of estate planning. First, set your goals. Next, create an inventory of your assets. Then, choose your fiduciaries, draft the necessary documents, fund and organize your estate, and finally, review your plan regularly. Step 1. Define your goals. This is crucial as it shapes your entire plan. Think about who you want to benefit and how you want your assets distributed. Step 2. Inventory your assets. Knowing what you have helps in making informed decisions about your estate plan. This includes everything from property to bank accounts. Step 3. Choose your fiduciaries. These are the people you trust to carry out your wishes, like executors or trustees. Choose wisely. Step 4. Draft your documents. This typically includes a will, a revocable living trust, and powers of attorney. Each document serves a specific purpose in your plan. Step 5. Fund and organize your estate. This means ensuring your assets are properly titled and beneficiaries are designated. Don't let your trust go unfunded. Step 6. Review your plan regularly. Life changes, and so should your estate plan. Make it a habit to check in every few years or after major life events. Now let's talk about costs and timelines. DIY kits can be affordable, but hiring an attorney can provide peace of mind. Expect to spend anywhere from a few hundred to several $1,000s, depending on complexity. Typically, the process from consultation to signing can take 2 to 6 weeks. Remember, funding your trust is an ongoing task that requires attention. To wrap up, remember these 3 key takeaways. Plan, fund, and review your estate plan regularly. It's essential for your peace of mind.
In this video, we'll talk about what you need to know about the advantages and disadvantages of establishing a trust. If you're contemplating setting up a trust, this video is designed to help you make a more informed decision. Let's get started. What is a trust and why is it important? First, let's answer a common question. What exactly is a trust? A trust is a legal arrangement that allows a third party, called a trustee, to hold and manage assets on behalf of beneficiaries. Trusts are commonly used in estate planning, wealth management, and asset protection. They can help individuals achieve various financial and personal objectives, such as providing for loved ones, reducing taxes, or ensuring privacy. Now that you understand what a trust is, let's move on to explore the different types of trusts you can establish. There are many types of trusts, each serving a specific purpose. Some common types include revocable living trusts, irrevocable trusts, testamentary trusts, special needs trusts, charitable trusts. Each type of trust has its own set of advantages. Let's take a closer look. Trusts offer a multitude of benefits. First, they give you significant control and flexibility over how your assets will be managed and distributed. You can establish specific terms and conditions, aligning your trust seamlessly with your unique goals and needs. Another major advantage is probate avoidance. Probate is a legal procedure that validates a will and distributes assets. Trusts, however, bypass this process entirely, enabling a faster and more confidential asset transfer to your beneficiaries. Tax benefits are also on the table. Some trusts can substantially minimize estate, gift, and income taxes. For instance, an irrevocable trust can effectively reduce your taxable estate, offering potential tax savings for your beneficiaries. Lastly, trusts are excellent tools for asset protection. They can shield your assets from creditors, lawsuits, or even divorce proceedings. While trusts offer significant advantages, it's essential to also consider the disadvantages: complexity and cost. Even though trusts are highly beneficial, they come with some drawbacks. The most glaring ones are their complexity and associated costs. Establishing a trust requires experienced legal guidance, and there may be some administrative fees involved. Additionally, some trusts, particularly irrevocable ones, lack flexibility. Once established, they can't be easily changed or dissolved without the beneficiary's consent. Finally, trusts can sometimes fuel conflicts among family members or beneficiaries, especially if the trust is perceived as unfair or if the trustee is not acting responsibly. Understanding both sides of the coin can help you make a well-informed decision about whether a trust is right for you. A trust can offer numerous advantages, such as control over asset distribution, probate avoidance, potential tax benefits, and asset protection. However, there are some drawbacks to consider, like the complexity and cost of establishing and maintaining the trust, potential irrevocability, and the possibility of conflicts among beneficiaries. For more information on each type of trust, explore some of our other videos where we break these down individually. If you found this video helpful, remember to like and subscribe. Thank you for watching. Welcome to our series on starting a business. Today, we're going to discuss the key legal steps you need to take when starting a new business. Understanding these legal considerations is crucial for ensuring your business operates smoothly and is set up for success. First, let's talk about choosing the right business structure. The most common structures are sole proprietorship, partnership, limited liability company, or LLC, and corporation. Each structure has different implications for liability, taxes, and management. A sole proprietorship is the simplest form but doesn't provide personal liability protection. An LLC offers liability protection and flexible tax options, making it a popular choice for small businesses. Corporations provide the most liability protection but come with more regulatory requirements. Next, you need to register your business. This involves choosing and registering your business name, often called a DBA, or doing business as. You'll need to file the necessary paperwork with your state and local authorities. Obtaining the necessary licenses and permits is another key step. The requirements vary depending on your business type and location. For example, a restaurant may need health permits, while a construction company may need specific contractor licenses. Research the licenses and permits required for your business and apply for them before you start operating. Understanding your tax obligations is essential. Start by obtaining an Employer Identification Number, or EIN, from the IRS. This number is used for tax filings and other business activities. You should also understand your obligations for sales tax, payroll tax, and income tax. Consulting with a tax advisor can help ensure you meet all your tax responsibilities. Creating a business plan is both a strategic tool and a legal consideration. A comprehensive business plan includes an executive summary, market analysis, and financial projections. It helps guide your business decisions and can be crucial for securing financing. Setting up your business finances is important. Open a business bank account to keep your personal and business finances separate. Set up accounting and bookkeeping systems to track your income and expenses accurately. Understanding your business insurance options is also important. Insurance can protect your business from various risks, such as liability claims and property damage. Employment law considerations are crucial if you plan to hire employees. Understand the difference between hiring employees and independent contractors. Comply with employment laws regarding wages, benefits, and workplace safety. Creating employment contracts and an employee handbook can help outline expectations and legal requirements. Protecting your intellectual property is vital. This includes trademarks, copyrights, and patents. Register your intellectual property to prevent others from using your brand or products without permission. Drafting key contracts and agreements is essential for legally binding business relationships. This includes partnership agreements, client contracts, and supplier agreements. Having clear, written agreements helps prevent disputes and outlines each party's responsibilities. Compliance with industry regulations is critical. Each industry has specific regulations that businesses must follow. Ensure you understand and comply with these regulations to avoid legal issues. Seeking professional advice is highly recommended. Consulting with legal, financial, and business advisors can help ensure you're taking the right steps. In conclusion, starting a business involves several key legal steps: choosing the right business structure, registering your business, obtaining necessary licenses, understanding tax obligations, creating a business plan, setting up finances, complying with employment laws, protecting intellectual property, drafting key contracts, and ensuring industry compliance. Taking these steps will help you build a solid legal foundation for your business. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified attorney or business advisor. See you.
A special needs trust is a type of trust that gives an individual with special needs access to funds in the trust without losing benefits provided by public assistance programs. Public assistance programs set up for people with special needs are generally predicated on income and asset limitations. The limitations may be surprisingly low in your state. However, money or assets that belong to the special needs trust generally do not count toward the purpose of qualifying for public assistance. By properly setting up and funding a special needs trust for the individual with special needs, they will have additional funds from the trust while still qualifying for public benefits. Improperly setting up or funding a special needs trust will generally result in loss of assets or loss of public benefits. Consult with a professional. All forms of trusts are important asset planning and protection tools that have their specific place. For more information on wills or trusts, contact a professional. A trust is a legal document that acts like a bucket to hold assets and contain a set of rules and instructions. The person in charge of that bucket is called the trustee. There are several types of trusts, such as a revocable trust, an irrevocable trust, a pet trust, a charitable remainder trust, and more. An irrevocable trust is a type of trust that cannot be modified, amended, or terminated without the permission of the grantor's beneficiary or beneficiaries. The grantor can give assets to the irrevocable trust. Doing this makes the irrevocable trust the owner of the assets and removes the grantor as the owner of those assets. The assets no longer belong to the grantor from a tax, estate recovery, and Medicaid perspective, allowing for advanced estate planning techniques. Irrevocable trusts are complicated and should be created by a professional. All forms of trusts are important asset planning and protection tools that have their specific place. For more information on wills or trusts, contact a professional. Understanding special needs trusts. In this video, we will explain what a special needs trust is, its benefits, types, key considerations, and common mistakes to avoid. A special needs trust, or SNT, is a legal arrangement designed to manage assets for the benefit of a person with disabilities without disqualifying them from government benefits, such as Medicaid or Supplemental Security Income, known as SSI. The primary objective is to enhance the quality of life for the individual by providing financial support for needs not covered by government programs. Special needs trusts offer numerous benefits. They ensure that the beneficiary continues to qualify for essential government benefits, provide a steady source of funds for additional care, safeguard the beneficiary's assets from creditors, allow professional management of funds, and offer peace of mind to families. There are three main types of special needs trusts. First-party special needs trusts are funded with the beneficiary's own assets, such as an inheritance or a personal injury settlement. Third-party special needs trusts are funded by someone other than the beneficiary, typically parents or grandparents. Pooled special needs trusts are managed by nonprofit organizations and pool resources from multiple beneficiaries for investment purposes, while maintaining individual accounts for each beneficiary. When creating a special needs trust, there are several key considerations. Selecting the right trustee is crucial. They must be knowledgeable about public benefit programs and capable of managing the trust assets effectively. Funding the trust properly is also essential, with common sources including gifts, inheritances, life insurance policies, and personal injury settlements. The trust document must be carefully drafted to comply with legal requirements and protect the beneficiary's eligibility for government benefits. Regularly reviewing and updating the trust ensures it continues to meet the beneficiary's needs and complies with current laws. Avoiding common mistakes is important in maintaining the effectiveness of a special needs trust. Ensure the trust is adequately funded to cover long-term needs. Choose a trustee with the necessary expertise and commitment. Properly structure the trust to preserve government benefit eligibility and regularly update the trust to align with the beneficiary's evolving needs and changes in the law. Setting up a special needs trust is a compassionate and prudent step in securing the future for someone you care about. It provides financial security and enhances the quality of life for individuals with disabilities. Seniors must show that they own nothing more than around $2,000, and they must also show that they have not given away money or assets over the prior 5 years. The look-back period, or the transfer penalty, would charge that senior for their generosity. Depending on the size and number of the gifts, the penalty could be substantial. Many wrongly think that there is no penalty for gifts of up to around $15,000 annually. That misunderstanding confuses tax law with Medicaid law. The Medicaid rules are entirely different from the tax rules. In the Medicaid context, gifts of any amount that are given during the look-back period can be penalized. There are exceptions, including gifts to spouses and siblings under certain circumstances, disabled children, and children who are caregivers and who live at home with the elder for a span of time. But overall, gifts and Medicaid do not belong together. The Medicaid rules are complicated, and the consequences for mistakes can be very costly. There are a number of options to protect assets and still qualify for benefits, but these options must be weighed with great care. This is why it's best to consult attorneys who are experts in Medicaid law. Contact Heritage Law Office today for more information on long-term care planning, Medicaid, and gifting. When you gift your home to your children, if they ever sell the house, they are responsible for paying taxes on the value gained during their ownership, as well as the value gained during your ownership. For example, if you bought a house for $100,000 and it is now worth $200,000, when your children sell the house, they will owe capital gains taxes on the $100,000 value gained, as well as any value gained during their ownership. However, assets that are left to heirs receive a step-up in cost basis. A step-up in basis adjusts the value of an asset when it passes from an owner to their heir at death. This means the value the house has gained during your ownership will not be subject to capital gains taxes when the property is sold. In the same scenario, if your children receive the $200,000 value house as an inheritance, upon selling the house, they will now only owe capital gains taxes for value added to the house during their ownership, instead of the value gained during your ownership as well. A house can benefit from the step-up in basis by passing the assets through a will, life estate, or trust. Contact Heritage Law Office for a free consultation.
Most people think once they've written a will, they're done. But here's the biggest mistake. They never update it. Life changes, fast. Got married, had a child, got divorced, bought a house. All of these are reasons to review your will. An outdated will can cause confusion, delays, or even get challenged in court. Set a reminder to check your will every few years, or any time your life changes. It's a simple habit that can save your family a lot of stress later.
Medicaid provides health coverage to millions of Americans, including eligible low-income adults, children, pregnant women, elderly adults, and people with disabilities. Medicaid is administered by states according to federal requirements. The program is funded jointly by states and the federal government. The Medicaid system will pay for your care costs, including a stay in a nursing home if you meet certain qualifications. The Medicaid system has an asset limit. As of the day this video was produced, as an unmarried person in Wisconsin, you must have less than $2,000 in assets to qualify for Medicaid. If you have more than $2,000 of assets, you must first spend your assets on qualifying expenses until you drop below the asset limit. Once you drop below the asset limit, the Medicaid system will cover your costs. Assets are separated into two categories: countable and non-countable. Countable assets count towards the asset limit of $2,000. Some examples of a countable asset may include cash, your bank accounts, and stocks. Non-countable assets do not count towards the asset limit of $2,000. Some examples of a non-countable asset may include a first automobile, money prepaid for funeral expenses, or a primary residence if a spouse still resides in that home. One of the methods in pre-planning for Medicaid is to strategically turn your countable assets to non-countable assets. Doing this will help preserve the value of your assets, while dropping you below the asset limit, qualifying you for Medicaid benefits. We work with you to find the best methods and options of converting assets to non-countable assets to preserve the most value for you and fit your specific needs. Contact one of our attorneys at our Wisconsin, Minnesota, or California locations to make sure your assets are properly protected. And for more information on wills, trusts, life estates, Medicaid planning, and estate planning, probate is the legal process that occurs to your estate after you pass away. During this legal process, a court will monitor the process of paying your debts and distributing your estate to the proper heirs. The probate process will take several months at minimum to complete and may take longer, depending on the complexity of your estate. Through proper planning, probate can be avoided, saving time and money. Tools such as a trust, life estate, joint ownership, and payable or transfer on death designations may be able to avoid probate. A will does not avoid probate as it is designed to go through the probate process. Speak to a professional today.
Think a will is enough? Here's why a living trust might be the smarter move. First, living trusts avoid probate. Unlike a will, a living trust keeps your assets out of court. That means faster transfer to your loved ones and no costly probate fees. Second, living trusts provide privacy. Wills become public record, but trusts stay private. Your family matters, stay your family's business. Third, living trusts have flexibility. It's called living because you can change it any time while you're alive. Update it as life changes. And fourth, living trusts provide continuity. If you become incapacitated, your trustee can step in immediately, with no court delays. Bottom line, a living trust saves time, money, and stress for your family. Want more estate planning information? Hit subscribe.
In this video, we will discuss how to amend a living trust, including the reasons for making amendments and the steps involved in the process. A living trust, also known as a revocable trust, is a legal document created during a person's lifetime that designates a trustee to manage the individual's assets for the benefit of the beneficiaries. One of the main advantages of a living trust is that it allows for the easy transfer of assets without the need for probate. There are several common reasons why you might need to amend a living trust. You may need to add or remove beneficiaries due to marriage, birth of children, or death. You might want to appoint a new trustee or successor trustee. Perhaps you need to modify how the assets are distributed among beneficiaries. Or you could be adding newly acquired assets to the trust. changes in personal circumstances, such as marital status, financial status, or health conditions, can also necessitate amendments. To amend a living trust, follow these steps. First, review your original living trust document to understand its provisions and identify the sections that need changes. Next, decide on the type of amendment. There are two primary methods: a trust amendment for minor changes or a restatement of the entire trust for major changes or multiple amendments. Then, draft the amendment. Clearly title the document as an amendment to the living trust, specify the date of the original trust and the date of the amendment, detail the specific changes being made, and include a clause reaffirming the unchanged portions of the trust. Sign and notarize the amendment. Both the grantor and the trustee, if different from the grantor, should sign the document in the presence of a notary public. Attach the amendment to the original trust document to ensure all parts of the trust are easily accessible and legally recognized. Finally, notify all relevant parties, including trustees, beneficiaries, and financial institutions, of the changes to the trust. When amending a living trust, it's important to maintain consistency in the document to avoid any confusion and potential legal disputes. Consider how the amendment might affect your estate taxes and consult with a tax advisor if necessary. If you amend your living trust, you may also need to update related estate planning documents such as wills, powers of attorney, and beneficiary designations. When changing successor trustees, choose someone you trust to manage your assets responsibly. In summary, amending a living trust involves reviewing the document, deciding on the type of amendment, drafting the changes, signing and notarizing, attaching the amendment to the original trust, and notifying relevant parties. While it's possible to amend a living trust on your own, consulting with an experienced attorney is highly recommended to ensure that the amendments are legally valid and correctly executed. An attorney can provide guidance tailored to your specific situation and help avoid common pitfalls. Establishing an irrevocable trust can be a complex process that requires a comprehensive understanding of specific laws and procedures. This involves determining the trust's beneficiaries and transferring asset ownership into the trust. Guidance from a knowledgeable lawyer can make the process easier to navigate. Each trust is created for a unique purpose, whether to minimize estate taxes, to provide for a special needs family member, or to protect assets from creditors. Determining your purpose is essential to guide the rest of the setup process. Next, select the right type of irrevocable trust. There are various types of irrevocable trusts, such as charitable remainder trusts, life insurance trusts, and qualified personal residence trusts. Each trust has its pros and cons, and an experienced attorney can help you decide the most suitable one for your circumstances. The next step is to choose your trust. The trustee is the individual responsible for managing the trust based on your guidelines. This could be a trusted friend, a family member, or a professional trustee like a bank or trust company. The chosen trustee should be reliable, honest, and well organized. Next, you need to identify your beneficiaries. Beneficiaries are those who will ultimately receive the assets in the trust. It's crucial to clearly specify who these beneficiaries are and what they are entitled to receive. Next, you will need to create and sign your trust document. The trust document is the legal agreement that outlines the trust's terms, including the trustee's responsibilities and the beneficiary's rights. After the document is drafted to your satisfaction, it must be signed in the presence of a notary. Next, store the trust document safely. After the trust document has been signed, it should be securely stored. Both your trustee and beneficiaries should know its location and how to access it if needed. Next, you will need to transfer assets into the trust. The step of transferring assets into the trust is critical. Depending on the asset type, this may require changing titles or deeds or merely transferring funds. Remember, once an asset is transferred into an irrevocable trust, it generally cannot be removed. Here are some key considerations and benefits. The laws governing the creation and management of irrevocable trusts can vary depending on the state you are located in. Understanding these state-specific laws is essential for ensuring the trust's validity and its ability to meet its intended objectives. When establishing an irrevocable trust, it's crucial to consider the tax implications. Depending on the type of trust and the assets involved, there may be federal and state tax consequences. Now, we'll discuss the benefits of an irrevocable trust. An irrevocable trust is a legal entity that, once established, generally cannot be altered or canceled without the consent of the beneficiary. It offers several benefits like tax advantages, protection from creditors, and assurance that your estate will be managed as you wish. One of the primary advantages of an irrevocable trust is the privacy and asset protection it offers. Because the assets are no longer in your name, they are safeguarded from creditors and legal claims. Do I need a lawyer to set up an irrevocable trust? Establishing an irrevocable trust can be complex and mandates a thorough understanding of the law. A lawyer can guide you through the setup process, ensure all legal stipulations are met, and help you understand the trust's implications. Setting up an irrevocable trust is a comprehensive process that involves understanding various laws, selecting the right type of trust, choosing a competent trustee, and considering both tax implications and asset protection benefits. While it may seem complex, seeking the guidance of a knowledgeable legal expert, like those at Heritage Law Office, can simplify the process and help you achieve your financial and estate planning goals. If you have any questions, please leave a comment and we'll try to answer them. Don't forget to like and subscribe for more helpful content like this. Thank you for watching.
Is a Medicaid asset protection trust worth it? Let's do the math. A typical nursing home stay costs $9,000 to $11,000 per month. That's over $100,000 a year. 70% of people over 65 will need nursing home care at some point. 1 in 5 will need care for more than 5 years. We help clients set up a Medicaid asset protection trust for $8,500. A one-time cost that can protect your home or savings from being spent down in long-term care. If Medicaid covers your nursing home bill even 1 month earlier than it would have without the trust, you've already recovered the cost. Stay 6 months in a facility? You could save over $50,000 in protected assets. Stay 12 months? That number doubles. It's not just about the money. It's about peace of mind, preserving your legacy, and having options. If you die without a will, the government decides who gets everything you own. Yeah, everything. Estate planning isn't just for the rich or the old. If you have a bank account, a car, a pet, or a kid, this is for you. Here are 3 things every adult needs: a will, a power of attorney, and a healthcare directive. And no, it doesn't take months. You can set this up in a short period of time. Without a plan, your loved ones could face court delays, legal battles, and stress right when they're grieving. Don't leave a mess. Start your estate plan today. Even a basic plan is better than nothing.
An estate plan is a collection of legal documents and strategies that outline how your assets and affairs will be handled in the event of your death or incapacity. Key components of an estate plan include wills, trusts, powers of attorney, and healthcare directives. There are several compelling reasons to have an estate plan. First, it ensures that your wishes are followed regarding the distribution of your assets and care of your dependents. Second, it protects your assets from unnecessary taxes, expenses, and legal fees. Third, it provides for your family by outlining your intentions clearly, reducing stress and uncertainty for your loved ones. Without an estate plan, your estate may face significant legal complications and delays. This can lead to increased costs and taxes, reducing the inheritance you leave behind. Additionally, the absence of clear instructions can result in family disputes and conflicts over your estate. Starting an estate plan involves several key steps. Begin by taking inventory of your assets, including property, investments, and personal belongings. Decide on your beneficiaries and how you want your assets distributed. Next, consult with an experienced attorney to draft the necessary legal documents, such as a will or trust. Regularly review and update your estate plan to reflect changes in your life, such as marriage, divorce, or the birth of a child. An estate plan isn't just about distributing your assets. It also includes making decisions about your healthcare and financial affairs if you become incapacitated. Powers of attorney and healthcare directives allow you to appoint someone you trust to make decisions on your behalf, ensuring your wishes are respected. Having an estate plan is crucial for ensuring your wishes are respected and your family is protected. Don't wait until it's too late. Contact an attorney to start your estate plan today. This proactive step can provide peace of mind and security for you and your loved ones. Thank you for watching. Make sure to like and subscribe for more.
In this video, we will explore the essential differences between trusts and wills and answer some common questions to help you understand these important estate planning tools. A will is a legal document that outlines how your assets will be distributed after your death. It must go through the probate process, which can be time-consuming and public. A trust, on the other hand, is a legal arrangement where one party holds and manages assets on behalf of another. Trusts can often avoid probate, providing a quicker and more private way to distribute assets. So, do you need both a will and a trust? The answer depends on your unique circumstances. Wills are crucial for naming guardians for minor children and specifying final arrangements. Trusts, however, can manage and distribute assets efficiently and provide benefits during your lifetime, especially if you become incapacitated. Having both can ensure comprehensive coverage for your estate. Now let's look at the different types of trusts and their benefits. Revocable trusts or living trusts can be altered during your lifetime and help avoid probate. Irrevocable trusts, which cannot be changed once established, offer asset protection and tax benefits. Charitable trusts support philanthropic goals and provide tax deductions. Testamentary trusts are created through a will and take effect upon your death. Special needs trusts ensure care for a beneficiary with special needs without affecting government benefits. Medicaid asset protection trusts help protect assets for Medicaid eligibility. Trusts can also be an effective tool for minimizing estate taxes. Irrevocable trusts, for instance, remove assets from your taxable estate, potentially reducing your estate tax burden. Charitable trusts can provide both estate tax benefits and charitable deductions. Specialized trusts like grantor retained annuity trusts, or GRATs, and qualified personal residence trusts, or QPRTs, can also help reduce estate taxes. However, not all assets can be placed in a trust. Retirement accounts like IRAs and 401ks typically cannot be transferred into a trust without triggering taxes. Your primary residence can be transferred into a trust, but it requires careful planning to avoid losing homestead exemptions. While vehicles can be placed in a trust, it can be complex and might not be necessary. Choosing the right trustee or executor is crucial for the smooth administration of your estate. Look for someone trustworthy, with financial acumen, and who is available and willing to fulfill their duties. Impartiality is also important, especially in families where potential conflicts may arise. Professional or corporate trustees are an option if you do not have a suitable individual in mind. It's also essential to regularly update your will or trust. Major life events like marriage, divorce, the birth or adoption of a child, significant financial changes, or moving to a different state can impact your estate plan. Regular reviews with your attorney can ensure your documents remain up to date and effective. Understanding the differences between wills and trusts and knowing when to use each is vital for effective estate planning. Trusts and wills can work together to provide a comprehensive plan that addresses all your needs. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified attorney or business advisor. See you in the next.
In this video, we will discuss the essential components of a strong estate plan and how each component can help you ensure your wishes are fulfilled. Creating an estate plan is crucial to ensure your assets are distributed according to your wishes after you pass away. Without an estate plan, the state will determine how your assets are distributed, which may not align with your intentions. Having a clear plan can give you peace of mind, and prevent potential conflicts among your heirs. A will is a legal document that outlines how you want your assets distributed after your death. It is essential to include key elements such as the designation of an executor, guardianship for minor children, and specific bequests. A well-drafted will can ensure your loved ones are taken care of and your assets are distributed as you desire. Trusts are another vital component of an estate plan. They come in different forms, such as revocable and irrevocable trusts. Trusts can help manage your assets during your lifetime and ensure they are distributed efficiently after your death, often avoiding probate. By setting up a trust, you can control how and when your beneficiaries receive their inheritance, protect assets from creditors, and potentially reduce estate taxes. Powers of attorney are critical for managing your affairs if you become incapacitated. Financial powers of attorney allow someone to manage your financial matters, while healthcare powers of attorney enable someone to make medical decisions on your behalf. Having these documents in place ensures your affairs are handled according to your wishes, even if you are unable to communicate them yourself. Healthcare directives, including living wills and healthcare proxies, are essential for outlining your medical preferences in case you cannot communicate your wishes. These documents guide your loved ones and healthcare providers in making crucial medical decisions, ensuring your healthcare wishes are respected. Ensure your assets go to the intended recipients by updating beneficiary designations on accounts such as life insurance policies, retirement accounts, and payable on death bank accounts. This step helps avoid probate and ensures a smooth transfer of assets. Regularly updating these designations can prevent unintended beneficiaries from inheriting your assets. It's important to review and update your estate plan periodically. Major life events such as marriage, divorce, the birth of a child, or the death of a loved one may necessitate changes to your plan to reflect your current wishes and circumstances. Regular reviews help ensure your estate plan remains aligned with your evolving needs and goals. In summary, a strong estate plan includes a will, various types of trusts, powers of attorney, healthcare directives, and updated beneficiary designations. Regularly reviewing and updating your plan ensures it remains aligned with your wishes. Contact us to learn more about creating a comprehensive estate plan tailored to your needs.
Own rental property. Here's why many investors put rentals in a trust. First, to skip probate. When you pass, property in a revocable living trust can go straight to your beneficiaries, faster, private, and with less cost. Second, to protect your privacy. Title held by a trust keeps your name off public ownership records. Third, for seamless management. If you're incapacitated, a successor trustee can step in to collect rent and handle repairs. What about asset protection? A revocable trust won't shield you from creditors, but some irrevocable trusts can offer protection and help with Medicaid planning. Taxes. With a revocable trust, you keep simple reporting now, and your heirs may receive a step-up in basis at death, reducing capital gains. Have an LLC? Let the trust own the LLC to combine liability protection with estate planning benefits. Got a mortgage? Review the loan and talk to your lender before transferring. Some moves to revocable trusts are allowed under federal law.
How to save over $100,000 through Medicaid planning. Nursing home costs are expensive and add up quickly. Within a short period of time, an entire life savings can be depleted by paying for the cost of a stay in a nursing home. With proper planning, however, substantial value may be able to be preserved and passed along. Here is an example of how to save over $100,000 through active Medicaid planning. Mary has a savings account worth $75,000 and an investment account worth $150,000, totaling $225,000. Mary will be requiring nursing home care starting next month. Nursing home expenses are $10,000 per month. Since Mary did not previously buy long-term care insurance or pre-plan, Mary will have to cover the costs out of pocket. Mary will have to pay out of the savings account and liquidate the investment account to pay for nursing care. In less than 2 years, Mary will be completely out of money. Medicaid is administered by states according to federal requirements. State rules may vary. For example, in Wisconsin, the Medicaid rules are structured so that once you have less than $2,000 in assets, Medicaid will pay for a required nursing home stay. Now that Mary has spent $225,000 and is out of money, public benefits will pay for Mary's nursing home care. Most people struggle with the concept of seeing their entire life savings depleted very quickly. They would prefer to transfer those assets to their children, family members, friends, or donate that money to charity, rather than seeing the money depleted. The easy solution seems to be to give away all your assets to drop below the asset limit and qualify for Medicaid. It is not that easy. Medicaid will not allow you to gift away all your assets and immediately qualify for Medicaid benefits. When gifting assets, Medicaid imposes a divestment penalty, causing an ineligibility period for Medicaid, time that must pass before public benefits will pay for nursing home expenses. The larger the value of the gift made, the longer the ineligibility period. The ineligibility period only starts counting down when you apply for Medicaid, and you would be otherwise eligible if the ineligibility period did not exist. At the time of this video, in Wisconsin, for every $303.38 given away, 1 day of Medicaid ineligibility is assessed. If Mary were to give away all her money, then apply for Medicaid, she would be ineligible for 2 years after applying and must find funds to pay for nursing home expenses. Here's one possible way to solve this issue. Again, there are different rules in different states, so be sure you talk to a professional. Mary has a total of $225,000. Mary splits the money into 2 different pieces. One that Mary keeps and turns into a stream of income, and one that Mary gives away to her family, friends, or charity. In this example, Mary converts $118,000 to a stream of monthly income. Income is treated differently than assets and do not count towards the Medicaid asset limit in Wisconsin. Mary receives the money back in equal payments over 12 months as income. We will discuss what Mary does with this cash flow in just a bit. Mary also gives away the remaining $107,000, either to individuals or to a special type of trust, an irrevocable trust. We believe an irrevocable trust is generally a better option for numerous reasons, which we will discuss in a separate video. At this point, Mary has no money remaining. She has gifted $107,000 to family, friends, or a trust, and has spent $118,000 to acquire a monthly income stream. Giving away money is considered a gift, causing a divestment period where Mary is ineligible for Medicaid benefits for a period of time. In Mary's scenario, a gift of $107,000 will cause an ineligibility period of 352 days. Now that Mary has less than $2,000, Mary can apply for Medicaid. Mary will be assessed an ineligibility period due to the $107,000 gift. However, the ineligibility period will now start counting down, and Mary will be eligible for coverage at the end of the 352-day ineligibility period. During the ineligibility period, Mary will use the monthly income stream to pay the nursing home expenses. That stream of income will expire the same time as Mary's ineligibility period, leaving Mary with less than $2,000 during the ineligibility period and when the ineligibility period ends. At the end of the ineligibility period, the income stream will stop, and Medicaid will cover Mary's nursing home expenses. Meanwhile, the assets that are set aside in the trust or gifted to individuals are saved. They are not subject to being spent on nursing home expenses. Rather than spending $225,000 on nursing home expenses and having the entire value of the assets depleted, $107,000 were able to be passed on to friends, family, or charity. Our next video will be about how Mary could have saved almost all of the $225,000 with proper Medicaid pre-planning. Medicaid planning and Medicaid applications are complicated, precise, and vary state to state. One mistake can be very costly. Contact one of our attorneys to make sure your assets are properly protected. In this video, we will discuss the top benefits of having a will. Creating a will is an essential step in ensuring that your wishes are respected and your loved ones are taken care of after you're gone. It is a critical part of estate planning that can save your family from unnecessary stress and conflict. Having a will provides peace of mind, knowing that your wishes will be followed after you're gone. For instance, imagine a family where the primary breadwinner passes away without a will. The family might face legal hurdles and financial uncertainties, adding to their grief. A will can prevent such scenarios by clearly outlining your wishes. A will helps avoid family disputes. Without a will, disagreements about asset distribution can lead to lasting rifts in family relationships. When your intentions are clearly outlined, there's less room for misunderstandings and disagreements among family members, ensuring a smoother transition during a difficult time. By having a will, you maintain control over the distribution of your assets. You decide who gets what and how much, making sure that your belongings, whether they are properties, family heirlooms, or financial assets, go exactly where you want them to go. This prevents the state from making these decisions for you. If you have minor children, a will is crucial for naming a guardian. This ensures that someone you trust will take care of your children, rather than leaving the decision to the courts. The emotional and legal security provided by naming a guardian cannot be overstated. A will can also speed up the probate process. Probate is the legal process of distributing your assets after death. By clearly stating your wishes, you help streamline the legal proceedings, reducing the time and cost associated with probate. This can significantly ease the burden on your loved ones during an already difficult time. Including charitable contributions in your will is another benefit. You can leave a legacy by donating to causes that matter to you, making a positive impact even after you're gone. In summary, having a will provides peace of mind, helps avoid family disputes, allows you to control asset distribution, ensures guardianship for minor children, speeds up the probate process, and enables charitable contributions.
For less than the cost of 1 month in a nursing home, this strategy can protect your entire life savings. The cost of nursing home care can be overwhelming, often exceeding $9,000 per month. Medicaid rules require that your assets fall below a certain limit before you can qualify for free nursing home care. This asset limit is often shockingly low, $2,000 in many states. This means you'll have to deplete your entire life savings before you can receive assistance. However, there is a solution: an irrevocable trust. By creating an irrevocable trust and transferring your assets into that trust, you can set aside and protect assets and qualify for Medicaid. When you transfer your assets into an irrevocable trust, the assets are no longer considered yours. The trust owns the assets. This means if you transfer your assets into this trust and you fall within the Medicaid eligibility limits, you can qualify for Medicaid without spending down your life savings. By using this strategy, you can qualify for free nursing home care while your assets in the irrevocable trust are protected and set aside for your loved ones. However, it's important to note the 5-year look-back period. Medicaid reviews your financial transactions for the past 5 years, and any transfers made during this period could result in an ineligibility period. Assets transferred longer than 5 years ago do not affect your eligibility. If you expect to require nursing home care within 5 years, you can still benefit from this type of estate planning, but the results are much more limited than if you planned at least 5 years ahead. Therefore, planning ahead is crucial. Start planning today to protect your hard-earned assets.
Welcome to our series on estate planning. Today, we're going to discuss digital estate planning and how to manage your digital assets and online accounts in your estate plan. In our digital age, it's crucial to include these assets in your planning. First, what are digital assets? Digital assets include anything stored electronically, such as email accounts, social media profiles, online banking, digital currencies, and more. These assets fall into several categories: personal, financial, social media, and business-related. To begin, identify your digital assets. Create an inventory listing all your digital assets along with usernames, passwords, and security questions. This inventory will be essential for your executor or beneficiaries to access and manage these assets after you're gone. Legal considerations are also important. The legal framework surrounding digital assets can be complex. Laws such as the Revised Uniform Fiduciary Access to Digital Assets Act, RUFADAA, help govern how digital assets are handled after death. Understanding these laws will help you create a more effective digital estate plan. Access and control are crucial elements. Ensure your executor or beneficiaries can access your digital assets. Use password managers and secure storage solutions to store your login information. This makes it easier for your trusted individuals to access your accounts when needed. Include specific instructions for handling your digital assets in your estate plan. For social media accounts, you may want to specify whether they should be memorialized or deleted. For email accounts, provide clear instructions on how to manage or close them. For online banking and digital currencies, outline how these assets should be transferred or accessed. Appointing a digital executor is another key step. A digital executor is responsible for managing your digital assets according to your wishes. Choose someone tech-savvy and trustworthy. Clearly outline their responsibilities and the extent of their authority in your estate plan. Regularly update your digital estate plan. Review and update your digital asset inventory to reflect new accounts, changes in passwords, and other updates. This ensures your plan remains current and effective. Protecting privacy and security is paramount. Take steps to protect your digital assets against identity theft and data breaches. Use strong, unique passwords, enable two-factor authentication, and store your inventory in a secure location. Communication is essential. Inform your executor and beneficiaries about your digital estate plan. Provide them with access instructions and necessary documentation to ensure they can manage your digital assets effectively. Let's look at a real-life example. Imagine someone who has significant online assets, including a blog generating income, multiple social media accounts, and digital currencies. By creating a digital estate plan, they ensure their digital executor can access these assets, manage them according to their wishes, and distribute any financial benefits to their beneficiaries. In summary, digital estate planning involves identifying your digital assets, providing access and control, including specific instructions in your estate plan, appointing a digital executor, regularly updating your plan, and protecting privacy and security. By including digital assets in your estate plan, you can ensure a smooth transition and protect your digital legacy. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified estate planning attorney. See you in the next video.
Can you sell a house that is in trust? If you own property and are thinking about establishing a trust to safeguard your assets, many people ask, can you sell a house that is in a trust? The answer is generally yes, although the process can be intricate, requiring a thorough understanding of the various steps involved. In this guide, we'll walk you through the basics of selling a house that is in trust, including what a trust is, how it affects the sale of your property, and what steps you need to take to sell your home successfully. We'll also offer some tips on how to ensure your sale goes smoothly and efficiently, so you can get the best possible outcome for your situation. What is a trust? First, let's define what a trust is. A trust is a legal arrangement that allows you to transfer ownership of your assets to a trustee, who will manage those assets on behalf of the beneficiaries you name in the trust. The trustee has a legal duty to manage the assets in the trust in accordance with your wishes, as outlined in the trust document. There are different types of trusts, but the most common is the revocable living trust. With this type of trust, you can transfer ownership of your assets to the trust during your lifetime and retain control over them as the trustee. You can also name yourself as the beneficiary, so you can continue to use and enjoy your assets as you did before they were placed in the trust. The trust becomes irrevocable after your death, at which point the assets are managed by the successor trustee you named in the trust document. An important question to ask is, how does a trust affect the sale of a house? If you've transferred ownership of your house to a trust, the trust now owns the property, not you personally. This means that you can't sell the house yourself. The trustee must handle the sale on behalf of the trust. However, as the grantor, creator of the trust, you can give the trustee the power to sell the property by including specific provisions in the trust document. For example, you can include language that allows the trustee to sell the property at any time or only under certain conditions, such as when the beneficiaries agree to the sale. It's important to note that the trustee has a legal duty to act in the best interests of the beneficiaries when managing the assets in the trust. This includes the sale of the house. The trustee must make decisions that are in the best interests of the beneficiaries, such as selling the property for the highest possible price or using the proceeds of the sale to benefit the beneficiaries in another way. Here are the steps to selling a house that is in trust. Now that you understand the basics of how a trust affects the sale of a house, let's walk through the steps involved in selling a house that is in trust. Step 1. Determine the trustee's powers. The first step is to review the trust document to determine the trustee's powers regarding the sale of the property. If the trust document grants the trustee the power to sell the property, the trustee can begin the process of listing the property for sale. Step 2. Choose a real estate agent. The trustee should choose a reputable real estate agent who has experience selling properties that are in trust. The agent should have a deep understanding of the legal and financial aspects of selling a trust property, as well as the ability to work collaboratively with the trustee and beneficiaries. Step 3. Prepare the property for sale. Before listing the property, the trustee should prepare it for sale. This may involve making necessary repairs and improvements, staging the property, and setting a fair market price based on comparable properties in the area. Step 4. List the property for sale. Once the property is prepared, the trustee can list it for sale with the chosen real estate agent. The listing should include all necessary information about the property, including any disclosures required by law. Step 5. Accept an offer and negotiate. When a potential buyer makes an offer on the property, the trustee should review it and consult with the beneficiaries before accepting or rejecting it. If the offer is accepted, the trustee should negotiate the terms of the sale, including the price, closing date, and any contingencies. Step 6. Transfer ownership of the property. Once the terms of the sale have been agreed upon, the trustee should work with the real estate agent and the buyer's attorney to transfer ownership of the property. This may involve completing necessary paperwork and providing documentation related to the trust and the sale of the property. Step 7. Distribute proceeds to beneficiaries. After the sale is complete and any outstanding debts and expenses related to the property have been paid, the trustee should distribute the proceeds from the sale to the beneficiaries in accordance with the terms of the trust. Selling a house that is in trust can be a complex process, but by following these steps and working with experienced professionals, it can be a smooth and successful transaction. Thank you for tuning in, and if you have any further questions or need legal advice, feel free to reach out to us at Heritage Law Office. If you found this video helpful, don't forget to like, share, and subscribe for more informative content.
Imagine you're one of the highest paid people on the planet, making $1,000 an hour. Sounds amazing, right? But let's see how far that really gets you. You work 10 hours a day, raking in $10,000 daily. Do that every day for a year, and you've made about $3.65 million. But wait, let's stretch this out. If you keep this insane pace for 40 years, you'll make around $146 million before taxes. But here comes the tax man. Assuming 40% goes to taxes, you're left with roughly $87 million after 4 decades of hard work. Here's the kicker. You work at 10 hours every single day for 40 years. And after all that, you'd still only have about 8.7% of $1 billion. Not even close to billionaire status. Remember, it's not just about how much you earn, it's about how much you keep. The wealthiest rely on smart tax planning and strategies to protect their legacy. So next time you hear about billionaires, remember, even if you made $1,000 an hour for decades, you'd barely make a dent. Billionaire money is about ownership, leverage, and scaling wealth beyond any salary.
Welcome to this video explaining Medicaid Asset Protection Trusts, or MAPT. Long-term care costs are substantial, with the national median for a private nursing home room projected at over $127,000 per year by 2026. Families plan early because long-term care can quickly deplete savings. Medicare coverage for long stays is limited, meaning Medicaid often becomes the payer. The goal of planning is to create a structure that helps preserve the home and savings, reducing financial stress. A Medicaid Asset Protection Trust is an irrevocable trust designed to move assets out of your name so they may not count against Medicaid eligibility after the look-back period. You, the grantor, give up direct control of the principal, but the assets may be protected for your beneficiaries. Medicaid eligibility depends on income and countable resources. Assets like bank accounts and second homes are usually countable. However, items like personal belongings and your primary residence, subject to certain equity limits, are often exempt or treated differently. The 5-year look-back period means that when you apply for Medicaid, the state reviews transfers made in the prior 60 months. Transfers without compensation, like gifting cash, can trigger a penalty period. A Medicaid Asset Protection Trust is most effective when created well before care is needed. A Medicaid Asset Protection Trust acts as a legal firewall. You create the trust, fund it by retitling assets, and the look-back clock starts. After 5 years, if properly structured, those trust assets may be treated as non-countable for long-term care Medicaid. For example, if Pat plans 5+ years ahead and moves their home and some savings into a Medicaid Asset Protection Trust, these assets may be shielded if nursing home care is needed later. Without a Medicaid Asset Protection Trust, savings may be quickly spent down. The pros of a Medicaid Asset Protection Trust include protecting your home and preserving savings. However, the key trade-off is that it is irrevocable, meaning you give up access to the trust principal. Transfers made within 5 years may still result in penalties. Common pitfalls include forgetting to fully fund the trust by retitling assets, keeping too much control over the principal, or making changes like selling the home without legal guidance. State rules vary, so always seek tailored advice. For married couples, spousal impoverishment rules protect a portion of the couple's resources and income when one spouse needs care. Federal law also exempts certain transfers of a primary residence from penalty, such as transfers to a spouse or a caregiver child. A high-level checklist for setting up a Medicaid Asset Protection Trust involves clarifying your goals, inventorying assets, choosing trustees, drafting the trust, funding it completely, and creating a maintenance plan to avoid accidental undoing of the plan. For next steps, find an elder law attorney in your state. Be prepared with your asset information and current estate plan. Review your plan annually, as even small changes can affect Medicaid eligibility. Plan early to protect your options.
A charitable remainder trust is an irrevocable trust that provides the donor with income for life and a current tax benefit for planning to donate assets upon their death. The donor gives away assets to an irrevocable trust, and during their lifetime they receive income from the trust. When they die, the remainder in the trust goes to the charities of their choice. When an asset is transferred into an irrevocable trust, it is removed from their estate. As a result, the assets in the trust cannot be recovered by creditors, and no estate taxes will be due upon their death. Additionally, because the assets are no longer owned by the donor, other advanced estate planning methods may be used in conjunction with a charitable remainder trust. Finally, for their generosity, the donor will receive an immediate income tax deduction when the charitable remainder trust is funded. The tax deduction amount is based on the current value of the assets that will go to charity. Irrevocable trusts are complex and must be precise. Be sure to talk with a professional. All forms of trusts are important asset planning and protection tools that have their specific place. For more information on wills or trusts, contact a professional.
Join us as we take on the challenge of organizing the essential documents needed for a comprehensive estate plan and learn how to avoid costly mistakes along the way. Estate planning is often viewed as a complex and daunting task, but having a comprehensive plan in place can provide peace of mind and financial security for you and your loved ones. If you don't have a proper estate plan in place, your family may be left to deal with the fallout, which can lead to lengthy and costly probate battles, family disputes, and even financial devastation. Without a clear plan, your assets may not be distributed according to your wishes, and your loved ones may be left with a huge mess to sort out. In addition, if you become incapacitated, your family may have to go to court to get a conservatorship, which can be a lengthy and expensive process. Furthermore, your medical wishes may not be respected, and your family may have to make difficult decisions on your behalf without knowing what you would have wanted. Moreover, without a comprehensive estate plan, your business and personal assets may not be protected, leaving them vulnerable to creditors, lawsuits, and other risks. In the worst-case scenario, not having a proper estate plan can lead to family feuds, lawsuits, and even financial ruin. It's a heavy burden to place on your loved ones, and it's one that can be easily avoided with a little planning and foresight. A comprehensive estate plan consists of several essential documents that work together to protect your assets and ensure your wishes are carried out. These documents include wills, trusts, powers of attorney, and healthcare directives. Each document plays a vital role in ensuring that your assets are distributed according to your wishes, your loved ones are protected, and your medical wishes are respected. A will is a legal document that outlines how you want your assets to be distributed after you pass away. It's a crucial document that ensures your wishes are carried out, and it can also appoint guardians for minor children. Trusts, on the other hand, are legal arrangements that allow you to transfer assets to beneficiaries while minimizing taxes and avoiding probate. Powers of attorney give someone the authority to make financial and medical decisions on your behalf if you become incapacitated. Healthcare directives, also known as living wills, outline your medical wishes if you're unable to communicate them yourself. Each of these documents is essential to a comprehensive estate plan, and they work together to provide a complete picture of your wishes and intentions. By having all of these documents in place, you can ensure that your loved ones are protected, your assets are distributed according to your wishes, and your medical wishes are respected. It's a vital step in planning for the future and avoiding costly mistakes. By having a comprehensive estate plan in place, you can rest easy knowing that your loved ones will be protected and your wishes will be carried out. If you don't already have a comprehensive estate plan in place, we encourage you to take the first step and schedule a consultation with an estate planning attorney today. It's a small step that can provide huge peace of mind and financial security for you and your loved ones.
When you pass away, your debts do not expire with you. Most debts